Well, good morning, everyone, and welcome to Uncivil Law. I hope you're having a great day. Today is the last day of June, at least as far as the Supreme Court appears to be concerned, because there's nothing on the calendar for tomorrow. There are 7 decisions to be announced from the bench today. And that is a plausible number for the Supreme Court to do in one day. So I'm expecting all the outstanding cases to be decided or otherwise disposed of today. I don't think they're going to carry anything in July. They don't normally do that. They've only done it like once in the last 20 years. So normally the end of June is your deadline. On today's dockets, the big one that everyone is looking forward to, I'm sure, is the Birthright Citizenship case. Let me spoil it for you. Supreme Court's going to decide 7-2, maybe 8-1, that people that are born here from illegal immigrants are nevertheless citizens of the United States. So that's that ruling. So let me go ahead and spoil that for you. Also on the docket today is the issue of mail-in ballots. Must mail-in ballots be received by Election Day? 5-4 or 6-3, yes, they must. And the other one is, of course, can states prohibit the transgenders from competing in sexes other than their biological sex? 6-3 or better, yes, states can do that. And then there's some other decisions, of course, beyond that, but those are the big ones. So that is what's going to happen today. We will be here for quite a while, I imagine, especially on the Birthright Citizenship case. We're going to speed read this thing as we do. So depending on who writes it, which if I were a betting man, I think Gorsuch probably writes it, may not be the last decision announced today because they announced them in reverse order of seniority, in case you care. So while we don't know what they're going to decide on any given day, the decisions they announce on any given day are announced in reverse order of seniority. So the least senior person, which goes in appointment order, except for the Chief Justice, because the Chief Justice is always most senior. So in reverse order of appointment, whoever's newest starts first. So since Gorsuch is a relatively newer appointment compared to, say, for example, other people, the Birthright Citizenship case, if it's written by Gorsuch, which would be probably my bet, it's going to be written by Gorsuch, because I'm not sure the Chief Justice wants a piece of that bullshit. So I think Gorsuch writes it. May not be the last decision announced today, and consequently, we may have to blow past it for other decisions during our speed read, but nevertheless, we will come back to it. I promise. You won't go wrong betting that Roberts will write it, but I feel like Roberts, probably all things being equal, doesn't necessarily want that piece of loaded ammunition. So I think the smarter money is on Gorsuch, but, you know, if it winds up being Chief Justice, no one will be surprised. So it's a very yeah. You could probably actually make a more intelligent bet by looking at the number of decisions each justice writes, because they do try to keep it relatively even. So I'm not sure what the count is of how many justices have written what. So you might be able to determine it by count, but putting that issue aside, I slightly favor Gorsuch to write it, but it would not surprise me in any respect if it is the Chief Justice. Do we have good news? I don't know yet. It's not 10 o'clock yet. We're all going to sit here patiently for 10 minutes and opine. How's your day? We have one piece of good news. I'm here and I'm happy. That's good news. Beyond that, there is, I suppose, one other piece of interesting news, or mildly interesting news. There's like 5 gun rights cases that are currently pending for the Supreme Court to potentially take. And the orders list that was released, they didn't address any of them. So they didn't kick them and they didn't do anything with them. So they relisted them again. I'm not sure if that necessarily means anything, but they're alive and kicking. So that's nice. It might be a sign that the Supreme Court is taking Second Amendment cases more seriously. After all, they decided 2 this year. Wow, what a banner year, right? They decided 2 Second Amendment cases this year. That's amazing. The Supreme Court has decided the Second Amendment exists, I guess. That alone is like a banner headline. Supreme Court finds Second Amendment, decides on cases. Wow, that's fun. So so 5 like Second Amendment cases are still alive and breathing. So that's cool. $45 months is a major accomplishment. Way to go indeed for 45 months. Well, illegal immigrants may not be able to be sat on a jury, but we're talking about their children, not them. So, yeah, maybe it's a chicken and egg thing. Can an illegal immigrant give birth to a legal citizen? I suppose from an evolutionary perspective, one could say this is a little bit like what came first, the chicken and the egg, which of course, from an evolutionary perspective, the answer is the egg. Because whatever laid the first chicken egg was not itself a chicken because it evolved into chicken form and thus the egg came first. But so yes, despite the fact they're an illegal immigrant, they might be able to give birth to legal because their status is not the thing that matters. So anyways, that was a very weird, convoluted analogy to make not that interesting a point. They aren't all winners over here on Uncivil Law. Sometimes we just say things and hope that they work out at the end. And then sometimes you get to the end and you're like, that didn't really go anywhere. What are my thoughts on the Supreme Court defining arms as an implement used for offense or defense? Yeah, that doesn't mean anything, though. Now, if they had said any arm used for offense or defense, that might be interesting. But I don't think they said any. They just said, it's used for offense or defense. At what point I'm over here like, well, no shit, Sherlock. Right? I mean, obviously, whatever else can be said about an arm, it's a tool. The tool is amoral. It doesn't have wants or desires. It can be used for good or bad. So no shit, Sherlock. An arm can be used for offense or defense. Tell me a different story, right? So that sentence, I read that and I'm like, sure. Yeah, absolutely. That does nothing for me in my Second Amendment theory, right? That does nothing for me to modify my Second Amendment theory. It's like, arms are used for offense and defense. I'm like, great. Shit, that's great. Great work. Really good. Yeah, really helpful. Thanks for that enlightening help. It really clarifies things a lot. Heartbreaker 6 says, I hope we have a great day. Well, we're off to a great start. At least I am off to a great start. I've been in a good mood as of late. Been in a good mood for a couple days, so that's plus. I went to the gym yesterday, didn't necessarily crush it, but I went and did some exercises. And hey, that ain't so bad, man. You know what I mean? It's all right. Let's see what SCOTUS blog is saying so far this morning. Not much. So far, SCOTUS blog. Yeah, so Birthright will not be unanimous. That there's no way on this earth. Well, I suppose there is a way, but you have to get Clarence Thomas's vote to make it unanimous, and that seems highly unlikely. I think getting a unanimous vote in favor of the children of illegal immigrants out of the Supreme Court, well, either way, to be honest, but getting a unanimous vote from the Supreme Court that children born of illegal immigrants are citizens seems implausible. You know, Clarence Thomas is going to be ornery. You got Clarence Thomas in dissent. You probably have Alito in dissent. Yeah, that's about it. In the dissent, they'll talk a lot about children of slaves. I have no doubt in my mind. Yeah, the dissent will talk a lot about the 13th Amendment and how it was meant for children of slaves, I'm sure. It's more likely to get a unanimous vote that only applies to freed slaves. Is it more likely? I'm going to go no, probably it's not, but we're arguing about who's going to blink first, Thomas or Jackson. And it's like, yeah, I'm not really feeling it. So do I think we lost? I think they're going to decide that children of illegal immigrants are birthright citizens. Yes. 7-2. Maybe 8-1. Probably written by Gorsuch, in my humble opinion. It's either Gorsuch or it's the Chief Justice for sure. I mean, do you give it to someone like Kagan? Because the Chief Justice the Chief Justice gets to decide, in case you're curious. The Chief Justice gets to decide which of them writes it. Whoever's in the majority, he's the one who gets to decide. Assuming he's also in the majority, which, seems like a pretty safe bet. So who does the Chief Justice give it to? Do you think he wants it for himself? I don't think so. Gorsuch seems like a play. Does he give it to Kagan? Possible, but Gorsuch feels like the better play. Gorsuch feels like the winner to me. Gotta drink more water, baby. Drinking water is good for everyone. We got 2 boxes today. That doesn't seem like 7 opinions. 2 boxes? We might be going into bonus time at the Supreme Court. Yeah. We only have 2 boxes at the Supreme Court today. For 7 decisions of this magnitude? I think we're going into bonus time. I think we're going into July. Are they trying to release an opinion on July 4th? I know it's a federal holiday and all, but still. Are they trying to release an opinion on July 4th because America birthday? That'd be hilarious. You think the Supreme Court thinks that way? Here's a gift for the nation's 250th birthday? That doesn't feel like a Supreme Court move. Isn't part of the question of whether the executive can clarify or narrow constitutional rights? Not really. I don't really see it that way. I mean, the Supreme Court could spend time talking about the executive order itself. And yeah, there's also a non-zero chance the Supreme Court doesn't decide the case, because they don't decide the case is always a healthy percentage to throw into any bet. So there is a non-zero chance that they per curiam it and kick it on some sort of bullshit like something executive order. That is definitely a non-zero chance. Yeah. So there's a non-zero chance that it's a per curiam. We don't want to rule on this issue, go away. But even for the Supreme Court, that's a lot. Could it be, though? If you want to put some money down on per curiam bullshit on a case this hot, wouldn't be the worst idea. Executive orders cannot change a constitutional right. That much is very clear. Yeah, that much you will not get a dispute from me. The executive order an executive order by definition is the chief executive giving an order to his lesser executives, namely the rest of the executive branch, to do a thing in a particular way. Yeah, executive orders are somewhat misunderstood. An executive order is an order from the CEO to lower person be like, hey, I want you to do this specific thing. Now, the CEO in this context, being the president, has some limitations. So he can only give a lawful order. So yes, the Supreme Court can say that's not a lawful order. Yes, the president cannot give an unlawful order. Yeah. So he can't change the Constitution. This is very true. If they do rule on birthright citizenship, there's no way it's retroactive. Because no one wants that nightmare. It will be forward-looking only. No one wants to try to go back in time and try to determine who are or are not birthright citizens. No one wants a piece of that. So if it's going to be a thing, which it won't be, it's only going to be forward-looking. That much I'm quite sure of. EOs are not law. That's true. They have the force of law, but they are not laws themselves. Okay, it's 10 o'clock sharp, baby. So we should start getting those decisions any moment now. Now, that doesn't that we don't get it right at 10 because first of all, they have to walk into the room. So right about now, a buzzer's going off in the Supreme Court. I know because I've been there, and they're starting to file in there. And unless they have any other business today, which I don't believe they do, they're going to start issuing decisions pretty soon. But just a minute more, baby. Usually by about 4 minutes past. It takes a little while for them all to sit down. Too bad they don't stream the justices reading their thing. Fair. Yeah, the Supreme Court also announces decisions from the bench, and sometimes dissent from the bench, and sometimes they can go on for a while. And the birthright citizenship case definitely feels like a case that's going to go on for a while. No. All right, we have our first case. Let's go ahead and put it on screen for all of whatever glory it has to share with us. Whoa. All right, cool. We've got Watson versus RNC. Federal Election Day, mail-in ballots. The Federal Election Day statute set the day for election of representatives, senators, and president on a Tuesday in November. They sure do. Mississippi permits certain residents, such as college students away from home and senior citizens, to vote via mail. Mississippi is one of roughly 30 states that count at least some absentee ballots mailed by Election Day, but received afterwards. So they have to be mailed by, but received afterwards. Okay. Absentee voters in Mississippi may dispatch their ballots by mail or common carrier, and all absentee ballots must be postmarked on or before the date of election and received by the register no more than 5 business days after. In 2024, the RNC, the Mississippi Republican Party, and various individuals sued Mississippi, contending that the federal law prevents Mississippi from counting election ballots received after Election Day. According to plaintiffs, the Election Day statutes use the word election to refer to 2 acts, the casting of ballots and the receipt of those ballots. So by setting the day for election, those statutes set the deadline for both. The Libertarian Party of Mississippi filed a similar suit, and district court consolidated, then granted summary judgment to Mississippi. The Fifth Circuit reversed, holding that Mississippi statutes are preempted because Election Day statutes require ballots to be received by Election Day. Okay, it went the other way. I was wrong. Held, the Federal Election Day statutes do not the Federal Election Day let's try this again. The Federal Election Day statutes do not prevent Mississippi from counting absentee ballots postmarked by Election Day, but received up to 5 days thereafter. Nothing in the federal election statutes requires ballots to be received by Election Day. The question before the court is narrow: whether counting ballots postmarked by Election Day but received up to 5 days later violates the law. Plaintiffs do not challenge the general practice of absentee voting, the use of the Postal Service or common carrier, early voting, or counting. Court also does not consider the scope of authority of Congress to rule in this particular domain, because why would we? The federal statutes do not preempt Mississippi because the defining element of election has always been the electoral choice of the candidate. As a relating statute, the Uniform and Overseas Voting Act confirms when federal law dictates ballots must be cast, state law governs when they must be received. It is a fundamental canon of construction that words generally mean the ordinary thing they normally mean. The court has likewise defined election as expressing the electoral choice, explaining that from time immemorial, election has been no more and no less than the expression by the electors of their choice. The electoral choice is made when the voting is complete, not when ballots are received. The most recent amendments to the presidential election day statute bears this out. While inserting the phrase election day into the statute, marking that date as a specific Tuesday, Congress also provided that when states modify the period of voting in response to certain force majeure, like for example hurricanes, the term election day shall include the modified period of voting. That Congress defined election day with reference to voting indicates voting is an act governed by statute. The relevant law, which requires states would permit absentee military and overseas voters to cast absentee ballots as backups, establishes federal absentee voting. In detailing the system, the relevant law repeatedly presupposes ballot receipt is a matter of state law. For instance, to avoid double counting, the relevant law provides that federal absentee ballots shall not be counted if a state receives a voter by the deadline for receipt under that ballot under state law, blah, 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 blah. Okay, great. All right, we got all that good stuff. Easy enough. Well, skim a little bit further. See if there's anything else we need to discuss in this. Okay, Barrett delivers the opinion in the court. Alito files a dissent in which Thomas Gorsuch and Kavanaugh join in a 5-4 decision. Barrett delivers the opinion with Roberts, Sotomayor, Kagan, and Jackson. In a 5-4 decision. Went the other way. Okie dokie. Now, for whatever it's worth, I would like to take note that this decision is narrow. Perhaps narrower than some people will understand to be. This presupposes that they're postmarked. So it doesn't deal with other issues. And it doesn't deal with the issues like signatures or anything else. It just deals with the only issue decided by this case is presupposing the state law allows for it, because state law governs, they say. Presupposing the state law allows for it. Assuming everything else about the ballot is otherwise legal under federal law, because we're only deciding one issue at a time. Assuming everything else is legal by the ballot itself under federal law, does the mere fact that it was received after Election Day, if postmarked by Election Day, prevent it from being counted? And the answer to that question is no. So it might be a bit narrower than people on the right might be thinking. So I know this isn't necessarily what the people on the right wanted. Nevertheless, I'm going to have to ask you to stop panicking. Okay. It doesn't end the world. It makes a fairly narrow decision that says, hey, this thing was postmarked by Election Day. State law allows for it to be received late. Is that cool? And the Supreme Court says, yeah, that's cool, and nothing else. So please stop panicking. Thanks. In a 5-4 decision, and I'm sure this does nothing for Amy Coney Barrett's continuing cred. Well, it doesn't necessarily say Congress can limit it. They didn't quite go into that issue either, which of course they're not going to. What are the limits of Congress in this domain? Who the fuck can say? So yes, Congress may or may not be able to pass a law, but that's another issue for another day. We don't do advisory opinions over here. You know better. So this doesn't in and of itself legalize ballot harvesting. It doesn't necessarily in and of itself legalize, election drop boxes, blah, 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 right? It's a very narrow decision. So you can stop panicking. We will read it in more depth, obviously, but that's the summary. We're not going anywhere for a while. I'm just waiting for the next decision to drop. They're currently reading. We're waiting with bated breath for the next decision. Let's see if there's anything else in this opinion, since we have a little bit of time while they're still reading. Skim the other parts that matter. Yeah, the question 4 is narrow. See, like this is like right away, right? Like that is the Supreme Court saying, stop panicking. Federal election statutes do not preempt Mississippi because the defining element has always been electoral choice, blah, blah, blah. The electoral choice is made when voting is complete, not when ballots are received. Fair enough. The most recent amendment to the presidential election day statute bears this out. When inserting the phrase election day in the statute marking the day of specific Tuesday, Congress also provided that states may modify the period of voting in response to like hurricanes and stuff. Okay, and then we've got this law, which permits absentee military ballots to cast ballots. Presupposes that it's state law. So the federal government has not preempted the field on this thing, despite the fact military, which would give which would give Congress even more power, right? So, like, if Congress passed the law, that would be one thing. If they passed the law dealing with military ballots in particular, well, because military also gets you some additional latitude, but they gave it to the states anyway, which Congress can do. If election day statutes establish a nationwide deadline, the refer to state would make little sense. Fair. This interpretation is consistent with Congress's requirement in Electoral College. Sure. The plaintiff that the contrary view, election day statutes require ballots to be received, heavily relies on historical practice. They did spend a lot of time talking about that, which I thought would go the other way, to be honest. But historical practice plaintiffs identify as not dispositive. Okay, fair enough. Plaintiffs agree the precedent policy cannot override the word choice. That's mostly true. Talking about the 19th century, interpretation statutes odd with the relevant law, which presupposes states' power to set ballot receipt deadlines. They offered a way to reconcile statutes, but their theories are unpersuasive. They cite Foster versus Love as a combination of actors, but Foster's not about ballot receipt, blah, blah, blah. Finally, plaintiffs' arguments about election integrity and voter confidence are directed to the legislature, not the court, right? Because we're not here to fix all your problems, right? Our mission in life is not to fix everything. Our mission in life is to decide whether or not it's okay that the ballot is postmarked. That's it. You have a lot of concerns about mail-in ballots and election security and stuff. Like, we're not asked to, and to a large degree, we'll not answer those questions. That's not our role, yo. Our role is the postmark thing right now. That's it. You have concerns about mail-in ballots and stuff? I don't know. Bring a different case or something. I don't know what to tell you. Yeah. Plaintiffs argues Mississippi system violates election day statutes because they allow the mail to be recalled. Even if that's right about Mississippi law, they would still lose the challenge had they pressed it in this litigation. The post-election day ballot receipt is itself unlawful, right? So, like, yes. Okay, so they allow votes to be recalled. Is that okay? The Supreme Court says we don't know, but it has nothing to do with this. Our issue was, hey, by the way, you got a ballot that was postmarked and you received it. Is that okay? Voters can recall their votes. Yeah, okay, but maybe, but that doesn't have a lot to do with the postmark thing. So go away. And that's pretty much it. Great, moving on. And we got another decision. Gene Angry Penguins, $5 says, I don't want to be reasonable. I even wore my brown pants. Fair enough. All right, we got another decision. Let's see. Yeah, so all the people, I know the Republicans are a little bit disappointed, but put down your torches. It's very narrow. Also, Congress could fix it, at least probably in this domain. So Stop panicking. It's going to be okay. Lots of issues left to be had, I'm sure. We'll spend more time reading it, though. Don't worry about it, I'm sure. Okay, anyways, we're going to talk about, how are we saying this name? Chaudhry? Chaudhry, we'll go with. We're going with Chaudhry versus United States. On May the 20th of 2019, a man robbed the credit union. You shouldn't do that. Local police officers learned from witnesses and surveillance footage that a robber had approached the credit union from the corner of adjacent church. Okay, this deals with cell phone. This is actually a pretty big case. This deals with cell phone geofence warrants. So I will tell you this case because I know the case now that I've read it. I didn't recognize it by name, but now that I've read it, I know exactly what the case is, right? So yeah, there was a bank robbery, and the police, as they're wont to do, got a geofence warrant. They looked for all cell phones that happened to be within the area of the bank, from period to period, right? They got a warrant for all the cell phones. And the question is, are geofence warrants legal? I'm going to go with yes. I'm going to go with yes, for if no other reason, then I'm not 100% sure the Fourth Amendment applies at all, because this deals with data that isn't on people's actual cell phones. This deals with data we got from, I believe in this case, Google, if memory serves correctly. They had Google services on, and so they asked Google for a listing of, that stuff, and they shared it with Google and, third-party doctrine. So is it legal? Yeah, third-party doctrine would be the answer you would expect. Let's see if that's the answer the Supreme Court gives, is third-party. But to be fair to that point, third-party doctrine has been a little bit questioned as of late. I don't know that they're necessarily ready to go off the edge of the page on third-party doctrine, but there have been grumblings about third-party doctrine. So are they going to narrow it or constrain it in some way? So best guess is the Supreme Court says third-party doctrine, but, so let's see if that's what's going on. Or if they do something even stronger, we'll see. In any event, there was a robbery. He was talking on a cell phone, so the police want to figure out who the robber is. On June the 14th, police officers went to a judge to get a warrant to Google, say, please give us all data about cell phones, all cell phones, within 150 meters of the credit union, from time to time, from this particular time to this particular time. Great. The application described the cell phone data through location history, which records, history every 2 minutes. Sure. The application also explained that cell phone data could help identify the robber, accomplices, or witnesses. Fair enough. We're not necessarily going to find the bad guy, but we might find other people who could potentially be helpful. So, fair enough. It's an investigation lead. Cool. Let's see. The warrant described a 3-step process the police would follow. At step 1, Google would provide anonymized data for 30 minutes before and 30 minutes after. Cool. At step 2, police would attempt to narrow the list, and Google would provide the additional anonymized data for that narrowed list. So first of all, give me everything within 150 meters from 30 minutes before to 30 minutes after. Okay. Step 2, they worked through that to narrow down people to exclude. Then they came up with a narrow list. Hey, Google, give us more specific information about these specific people. We would like to know more about them. Okay. The magistrate signed the warrant, and through the process, Google ultimately identified 3 cell phone users, including the petitioner, Okello Chaudhry, whose location data showed that he had entered the geofence area about 10 minutes before the robbery and head toward the residential area immediately after leaving the bank. Further police work, a federal grand jury charged Chaudhry with robbery and related firearms offenses, and he moves to suppress. No. According to Chaudhry, the officers had acquired the data through the Fourth Amendment search, and the warrant ostensibly authorizing the search was invalid. Under standard legal theory, no. Not unless they want to change standard legal theory, which, to be fair, you're talking to the people who are capable of doing that. So under standard answer, it would be go away. Does the Supreme Court want to say something different than go away? Let's find out. The district court found the geofence warrant plainly violated the rights enshrined in the Fourth Amendment, but declined the motion based on good faith. A divided fourth panel affirmed on different reasoning, wholly no search occurred because he did not have a reasonable expectation of privacy in 2 hours worth of location data. At least that no search relevant to him, sure. The Fourth Circuit granted rehearing en banc and affirmed in a 1 cents per cur with dividing. Blah, blah, blah. Hell, police officers conducted a Fourth Amendment search when they acquired the location data from Google because an individual has reasonable expectation of cell phone data information. Okay, the law just changed in a massive way, guys. Third party doctrine just took a shot. The law just changed in a very big way on the Fourth Amendment. The scale of this is a little bit difficult to fully appreciate right now, or for me to fully anticipate. Like, they're going to tell me the scale of this in a second, but this is, or at least was earlier today, the wrong answer. Now, I'm not saying this is a wrong answer as a matter of the Constitution. I'm saying this is a wrong answer as a matter of precedent. You just take that third party doctrine and just stamp it all day long until your hand bleeds, right? It's like, oh, I've got this beautiful stamp. It said third party doctrine, stamp, 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 right? And the Supreme Court said, put away your stamp. I'm like, what the fuck? I was just because it's a big change in precedent. Again, I'm not opposed to it for constitutional reasons. I'm not necessarily even surprised because, as I mentioned, the third party doctrine there's been grumblings. But the Supreme Court actually did it. Go to your knees like Planet of the Apes. You did it. You maniacs. You blew it up. That's basically what happened. How bad is it? I don't know yet. But the Fourth Amendment law just changed in a pretty serious way instantly. And I'm here for it. Okay. That happened. Is that the only cases? Oh, there's some more shit today. Oh, they've been announcing other decisions while I've been talking. Oh, fuck me. All right. Sorry. There's other decisions. Sorry. We'll come back to that. Damn, they're fast. Shut up. All right. We're turning our attention to Trump versus Cook. As a member of the governors of the Federal Reserve, can Trump fire people? In August of 2025, President Trump purported to fire Lisa Cook, a member of the Board of Governors. So this is Humphrey's executor dead? And the answer to that question is probably. Right. So this is, are we going to overturn Humphrey's executor? Probably. Can the president fire members of the executive branch? Yeah, probably. Yeah, that's probably where this is going. Let's find out. Cook was the first governor to be fired in the central bank's 111-year history. She promptly filed suit. She alleged her removal was not for cause as required, and the president had, in any event, failed to comply with statute. That she received pre-termination process. The district court granted a preliminary injunction to prevent her removal. The court must decide whether the district order should remain in effect pending cause of litigation. Oh, this is application for a stay. Oh, this is injunctive relief. Oh, we're not even going to decide the issue. Well, we might decide the issue a little bit. The United States has a long history of an independent central bank. Okay. The nation's first de facto central bank, the Bank of North America, predates our Constitution. The structure of the Bank of North America was unusual. It was owned in part by the government, in part by the public, run by directors accountable only to private stockholders, and yet maintained with the public purpose. Although the Bank of North America was short-lived, two more national banks have followed in its footsteps, both had similar goals, blah, 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 blah. 8 years later, hell, blah, blah, blah. The government has not shown that it's likely to prevail in legal arguments advanced in its stay. Accepting the government's position would in effect transform Federal Reserve for cause into at-will employment, interpret step out of step with step of Congress or nations protected. Government finds the president's termination of cause is wholly unreviewable. It's okay. All right, so Humphrey's executor is not dead. Wow, okay, I'm just getting all the predictions wrong today. I'm not doing great here on Prediction Land. Okay, what else we got today? Trump versus Slaughter. FTC. We're not doing birthright citizenship. God damn it. The Federal Trade Commission's regulatory agent advanced rulemaking held for causes contrary to separation of powers. Oh, we might be doing a little bit of the end of Humphrey's executive. Okay. And we are not doing any, we're not doing any of the big case. Well, we did mail in ballots, I guess. So we did mail in ballots, which isn't that big a deal. I know the Republicans will be sad, but it's not that big a deal. Calm the fuck down. We did mail in ballots, but we didn't do gays in sports, and we didn't do birthright citizenship. What the absolute fuck? We'll spend more time with it. Speed reading. We'll spend more time. Don't worry. We're going back and we're spending more time with these things. Yeah, yeah. Well, they split the baby on Humphrey's executor. It looks like. So which makes sense. They released two decisions at the same time, which might contradict each other. I've seen that kind of thing before. So they giveth and they taketh away. Okay, fair enough. Oh, the court did explicitly overrule Humphrey's executor in the FTC case. Oh, okay. We hadn't gone that far. I'm just reading SCOTUS's blog summary now, by the way, in case you're curious. I'm just trying to get an update on what's happening. So Humphrey's executor has been overruled. That is not a surprise. Humphrey's executor was a case that basically said the president can't fire certain members of the executive branch. It's been Humphrey's executor is 1930s, I think. In any event, it's been deeply questioned for quite a long time, right? So more than just grumblings, right? There have been the fact that Humphrey's executor is overruled is a total non-shocker, as opposed to the Fourth Amendment just changed me instantly before my eyes. Like the amount of grumblings on Humphrey's executor, there was serious, hardcore grumblings, and it's like, oh, they overruled Humphrey's executor. I'm like, oh, okay, sure, of course they did. Yeah. The Fourth Amendment thing caught me more by surprise. In any event, thank you, BevD7859 for the 20 gift membership. Yeah, I think it was FDR. I'm just trying to remember like when these cases are, right? Because like I'm not quite as sharp as I used to be. So like Humphrey's executor, I think it was New Deal, 1930s, 1940. It's like, that sounds right in my head. It's like, is he trying to remember exactly when these things were? And it's been questioned, I'd say, at least since Scalia's dissent in Morrison v. Olson. And yeah, so it doesn't surprise me that Humphrey's executor is dead. So we'll spend some time discussing that. And now I'm just reading. Yeah. And apparently, they're still trying to decide when the last day of the term is going to be. All right, uncivil law needs a quick break. Those are all the decisions for today. So we know that, by the way, for sure, because they gave them numbers, and they don't do that on the opinion page until they're all done for the day. So it's just those 4 opinions. So we have 3 left, which are birthright citizenship, gays in sports, and I forget I'm not sure. 1935? Okay. I would have thought it was slightly later. I would have said like 38. If you had asked me on a trivia contest when Humphrey's executor was, I would have said 38. So I guess 35 is close enough. You're within the ballpark of a couple of years. That's not too bad. So I'll give myself mostly credit. Transgenders, not gays. That's true. I apologize for the slight imprecision. Transgender, not gays. You're correct. I apologize. Do they limit the number of opinions per day? No. It's only 10:30, so why not drop the rest? Because. Is there a limit to the number of opinions in a day? No. Why is there no more opinions? Because. I'm glad to clarify that. Are they kicking the can down the road because the decisions will be controversial? Well, for a lot of historical and pragmatic reasons, really controversial decisions tend to be decided at the end of the term, which makes sense. I mean, they require the most time and attention, so they tend to clump together in June. It's pretty historically a thing. Yeah, the most controversial decisions tend to, not universally, but tend to clump in June. So unless you have a super controversial case that's like argued the first thing in October, which, then you're like, okay, then you're going to have a decision in February, right? But if they have a super controversial decision argued in December, it's like, probably June. It's just the way it goes. We got four opinions left to be decided. Apparently, there's a birthright citizenship case as well as 2 transgender athlete cases, which imagine those are consolidated, and there's a campaign finance case. Yeah. So basically 3 opinions. Yeah. So there's 4 cases left to be decided. Birthright citizenship, 2 transgender cases, which, yeah, that's basically one case, and campaign finance. And we're still trying to figure out exactly when that's going to be. The rest tomorrow? Possible. They haven't said. Maybe they'll say. Maybe they'll tell us. I'm not sure what they're waiting for. The only thing that's really surprising about it to me is that they're releasing, because the Supreme Court isn't complete morons, is that they're going to release it presumably, because what are they going to do? Release it tomorrow? The last day of June? I mean, I guess they can. But, if you have any sense whatsoever, you normally release bad news on Friday. It's take out the trash day for a reason. No one reads the Saturday paper, right? So you normally release bad, and, no one really watches the news on the weekend. So you release bad news on Friday. You get, the Friday evening news, but then Saturday and Sunday and then, then you lose a lot of the thrust from the news cycle. So normally you do Friday as take out the trash day, and the Supreme Court's not doing that. They're going to release this. What are they going to do? Release decisions on July 4th on a Friday, on a federal holiday, no less, on the celebration of the 250th birthday of the United States. We're going to release super controversial decisions on a federal holiday on July 4th. That seems like a bad plan. So probably not that. Yeah, all LawTube was expecting these decisions today? No shit. I mean, I would have expected them on Friday last week, but never mind. Because there was a day on Friday. We were here. So I would have expected I would have expected like it on Friday last week, because then you get everything I just said, right? You get your super controversial case, you dump it on a Friday, you get the benefit of the weekend, and you get some new outrage on Monday and make the whole thing go away. But we're not doing that over here. Supreme Court's doing what Supreme Court does. Unless it's 9-0, if birthright citizenship winds up being 9-0, if they can somehow squeeze Thomas's vote out of this thing, I'm just saying, man. I'm just saying. What would be a situation where there's a legal impetus to make a decision right away? Well, there wouldn't be necessarily a legal impetus, but there might be a practical impetus, right? If there was something that required a decision right now because the Supreme Court stalling itself is a problem in like a serious way, then maybe. But that isn't true here, right? There's no real pressure in that sense. The Supreme Court overturning birthright citizenship on July 4th. If the Supreme Court overturns birthright citizenship, which seems highly unlikely, not to say that you can't get there legally. I think you can get there legally. We've discussed the case, not necessarily in full depth, but we've discussed it. There are historical reasons from the people that wrote the 14th Amendment and what they wrote and what they discussed to reasonably exclude illegal immigrants. you can definitely get there. It's not like it's a batshit crazy thing to think. Nevertheless, I think you're going to have a tough time getting there with the practice in place, as strong as it is, for as long as it is. It's like, do you really want to do that? Probably no one does. No one really has the gut for that. So if they manage to somehow squeeze enough votes, I mean, where do they even get the votes from to overturn birthright citizenship? Right? You could get Thomas and Alito, and then from there, where do you go? Who's next? I mean, which one is going to do it? ACB? Roberts? That's a big boy decision. Do you think Roberts has those kind of balls? Gorsuch? You think you get anyone from the left? You think you can somehow, by some miracle, squeeze Kagan into a decision to overturn birthright citizenship? I mean, she's your best bet on the left. Kagan is your best bet on the left to try to squeeze a vote to end birthright citizenship. Do you think you can do it, though? Do you think you can get that out of Kagan? I don't know, man. That seems like a lot. Oh yeah, US v. Nixon. Oh yeah, well the fastest turnaround for the Supreme Court was the Pentagon Papers case. Yeah, that I think has the speed record. The Pentagon Papers case has the speed record. That went from filed in the district court to decision by the US Supreme Court in like 11 days flat. So the Supreme Court can ball. That's just not what they're used to doing. You could theoretically get Gorsuch out of it. Problem with Gorsuch is he's a textualist, and so that seems getting Gorsuch's vote seems difficult. You could get Kavanaugh. But where you get the other two votes, I don't know. In any event, I need a slight break. Talk amongst yourselves, and I'll be right back to discuss this in more depth. You saw me at WGL. What's WGL? Yeah. 5 days? Yeah. It was, yeah. Do they have the ability to hold the releasing these decisions till October? I mean, I guess hypothetically, it's just not what the Supreme Court does. They always release decisions by, well, almost always by the end of June. And they've stretched into July like once in the last 20 years, but they don't do that. Oh, Washington Gun Rights Channel. Oh yeah, that's cool. Yeah, I was commenting a little bit into the Washington Gun Law Channel people. Yeah, they're cool. I used to be much more of an expert on the Second Amendment. I'm still for lawyers. I'm still very exceptionally well educated. I used to be even more exceptionally well educated because, in the early parts of my career, I used to be legal advisors to some gun rights groups. So I used to know a lot more law and statistics like cold. I could recite a lot more stuff off the top of my head because it was stuff I was, a lot of that knowledge has, a lot of the finer details of that knowledge has since left my mind because, I don't exercise that muscle anymore. But, I'm still pretty exceptionally well educated on gun law. And I was like, oh yeah, I definitely want to roll with these people because it would be fun to get back in touch, and it would be fun to do some gun law with some gun rights people. Because it'd be fun to like reinvigorate a specialty that is latent. So that'd be fun. All right, I need a fiver. Talk amongst yourselves. I'll be right back. We're going to do this in more detail. I'll be right back. Is this working? Are you hearing this? Or are you just seeing a big logo? You can hear it? Excellent. Be right back. Okay, we're back, people. July 4th is Saturday? It is Saturday. I thought it was Friday for some reason. Never mind. All right. So let us do, just seeing if anything else, SCOTUS blog, if they have an announcement of what day thing is going to be. They don't seem to have a decision yet as to what when the rest of the decisions are going to be. All right. Let us do the Fourth Amendment case. Because, all right, first of all, this decision from the Fourth Amendment case, Alito filed a dissent, Thomas and Barrett joined. So it was 6-3. Okay. Let's read this decision. Justice Kagan delivered, I'm not surprised. In recent years, law enforcement officials have employed so-called geofence warrants to obtain information that technology companies collect about the user's cell phone location. Suppose that investigators know a crime was committed at a particular place and particular time, but they do not have a suspect. They may draw a geofence, a virtual perimeter around the crime scene, and get a warrant compelling a company to hand over data about cell phones located in the area near the time of the crime. Following a process specified in the warrant, the company will turn over the cell phone data and eventually identify by name one or more users. The geofence warrant at issue here was directed to Google and used to solve a bank robbery. Hundreds of millions of Google users have activated a service known as location history, which records the location of a user's cell phone every 2 minutes or so. Through a geofence warrant, police officers required Google to turn over location data, revealing cell phones within the vicinity of a bank around the time it was robbed. At the end of the multi-step process described in the warrant, Google gave the police 3 names. So initially, they asked for all the cell phones within 150 meters for 30 minutes before and 30 minutes after. So initially, they got a whole huge list. They then did some work to narrow that down and then asked Google for some names. And ultimately, they got 3 names, which they then followed up on through additional means to find out whether or not those were the bad guys or not. The federal government soon charged one of the individuals identified, Chartres, with committing the crime. Today, we consider how the Fourth Amendment applies to the use of the geofence warrants. Answering that question in full would mean deciding whether the police conducted a Fourth Amendment search when they acquired the cell phone data leading to the arrest, and if so, whether that search was reasonable given the features of the warrant they employed. We decide the first part of the inquiry today, concluding that police conducted a search when they gained access to location history data, which is not what you would have expected before, like right now. Chartres? Okay, Chartres it is. An individual has a reasonable expectation of privacy and records about cell phone data. See, this is like right here. Like that's the legal ball game and also a bit of a surprise. The reason it's a surprise is because the Fourth Amendment protects documents and records as well as the person themselves. The problem in question is that the documents and records in this case are not in the possession of the person, right? The Fourth Amendment protects you. We'll start with basics, right? The Constitution protects you and protects your individual rights. You know, that's not that hard of a concept. The Fourth Amendment protects the police from unreasonable searches and seizures involving persons, documents, records. Now, the key to that, of course, is that the records have to be your records, not about you, but your records. Records that you created are in your possession or control in some sense, right? So, you know, let's go to like basics. You know, it's 1930 and the police are investigating some bootlegging, right? And they stumble upon a still somewhere and a shed. And in the shed are some documents relating to purchase orders. And the purchase orders indicate that sales were made to a man named McPhee. And so they figure out who McPhee is and they arrest him for conspiracy or whatever. And like, that's not fair. I didn't do nothing. You can't get me, coppers. And the courts in the 1930s, and for that matter, 2025, and for that matter today, presumably, would say, well, you know, sorry about that and all, but the document the police used to find you was in possession of the bootleggers / distillers. You know, there was their business records. It may have been an illegal business, but it was still their business records. And we found you, and that's the thing, right? It's like, and so we're going to convict you and sentence you to jail, right? Because those records were in the possession of a third party. And so third party doctrine. But now we say there's a right to privacy, even though they are in possession of, and in the Google's case, created by the other entity. It's like, okay, that's interesting. We leave the Court of Appeals further question whether, given the warrant issued, the search here was reasonable. Okay, so we're kind of split the baby, which for Supreme Court, yeah. But it is a search. So now we're going to figure out whether or not it was a reasonable search. If I'm the Court of Appeals, I really hope they're going to tell me in this decision how to do that. It's like, yeah, it's a search. It's a reasonable search. Yeah, can you give me, I could use some notes. How am I going to do that? Please, I need some notes. Modern cell phones, we observed a dozen years ago, are such pervasive and intensive part of daily life. The proverbial visitor from Mars might conclude they were an important feature of human anatomy. True. Since then, the percentage of Americans who own smartphones have only increased. Today, more than 9 in 10 Americans own a smartphone. Sure. This means that they are likely addicted to apps. The people that are suing various technology providers for social media and other forms of addiction just got a new line to throw into their briefs. They're happy. Like, even the Supreme Court says they're addictive. I'd throw that into my brief in a heartbeat. Yeah, you can see that sentence popping up in different contexts immediately. Many of which collect and store detailed information about all aspects of a person's life. Among that information is a single fact most pertinent here, where a cell phone user was at a given time. Apps of many kind rely on that datum. Really? Datum? Really? You pretentious fucks? Your Maps apps want you to help navigate from point A to where you are to point B where you're going. Ride-sharing apps, of course, track your location when you're not using them, often do even when you are using them, and often when you're not. Weather apps want to tell you about local conditions. Fast food apps want to identify the closest burger and pizza joints. Fitness apps want to track your running routes, and so on. This case concerns a form of cell phone location data called location history, which Google Apps store. Sure. Location history is what it sounds like, a time-stamped record of every place the cell phone has been. Every 2 minutes or so, location history draws from an array of sources to log cell phone location. This includes Wi-Fi, Bluetooth, cell site, GPS, blah, 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 blah. Yeah, okay. When combined, the signals can determine cell phone locations within 20 meters. Sure. This also ascertains a phone's elevation, thus reveal what floor of the building they're on. If you're lucky, maybe. Wouldn't bank on it, but possible. By all accounts, these features make location history the most sweeping, granular, and comprehensive tool existing today for collecting and storing location data. Google repeatedly prompts users to enable location history, and over 500 million users worldwide have done so. The first prompt comes when the user initially establishes the account. If that spur, nice word choice, is ignored, another will arrive when a user sets up a Google app like Google Assistant, Google Maps, or Google Photos on his phone or other devices. Android, though not iPhone users, are specifically warned that their devices will not work correctly unless they turn on the history. And once the user does, The service runs and runs consistently in the background, regardless of whether the user has a Google app open or whether he's using the phone at all. Location history remains active. Yes, I mean, in this and many other contexts, we collectively are spying on ourselves constantly. This is why, as a practical matter, I'm not surprised that third-party doctrine is being reined in. I'm still a little shooketh because the scale of this is potentially massive. How much the scale of that is, I'm still waiting to be learned. I'm still learning it in real time. Is this biggeth or not biggeth? I don't know yet. I'm still reading because the Supreme Court might giveth and taketh away, and we haven't gotten to the end yet, so I don't know where this is going yet. Still, even if it's fairly narrow, it's importantly narrow. And it is true that we all collectively are spying on ourselves through location data and God knows social media. The self-snitching in every possible sense continues. All right. Google stores all location data history in the cloud rather than on the user device, though that choice makes no real difference to the user. Cloud computing refers to the capacity of internet-collected devices to display data stored on remote servers rather than on the device. Because it exists, Google can store information on servers where users can view it as if stored on a cell phone. The Ghost of Recon says, just wanted to say thank you from the stuff I've learned. My finals master's class with cyber law. Thanks to you, I had a really easy time. Excellent. This pleases me greatly. This pleases me greatly. I'm helping to educate you in a way that is manifesting in the real world and showing up on tests and stuff. This makes me happy. I am serving my job as an educator. Thank you. I'm glad that I was able to help. Good work and congratulations. And the answer, this is right up your alley. This is right up your alley because the answer is changing in real time, right before your eyes, right? This is the magic part of Supreme Court and why I like Supreme Court, right? Like if you had asked me at 9:50 Eastern time what the answer was, it wouldn't be this, right? The answer is changing right before our eyes. This is the fun part, man. That data exists someplace remote, but the user sees it, and the content user or context Google creates from it. The user thus can access a timeline showing where he's traveled, when, updates, blah, 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 blah. In the last decade, Google location history data has also served another function, though unknown to most users. That data is obtained through the geofence warrant, can enable law enforcement officers to solve hard-to-solve crimes. Such a warrant, as earlier described, seeks information about cell phones located in the vicinity of a crime scene at around the time the crime was committed. The goal is simple: find out who was there and who might have done it. Which, you know, feels like a pretty worthwhile goal. There are usually better ways to investigate an already known suspect, like seeking only his location data. Sure. I'm not sure why we need to specify that, but yes. Yeah, why would you do a geofence for if you're looking for a specific person? Feels like a, okay. And the mechanism is to use the offender's cell phone as an identifying device. The warrant specifies a time frame and a map and demands information about the cell phones and their users. There is some uncertainty about how often the technique in fact works. I'm not sure that's really either here nor there. Who cares? Except as to pragmatic concerns rather than legal concerns. But its use among law enforcement has flourished. Google first received a geofence warrant in 2016. The only thing that surprises me about that is it wasn't sooner. If they had said 2006, I would have believed them. 2 years later, it received 982, and 2 years after that, more than 11,000. Though the details vary, each has made the same essential demand. Tell us through location data who was there. Okay. Also, as those demands seem to profligate, Google worked with law enforcement officers to develop a three-step tool. At first, Google provides anonymized data. That data generally includes each phone's latitude, longitude, corresponding timestamp, and estimate of information accuracy and description of the source. The data at that stage shows each user's location within the geofence. At step 2 of the process, officials view the data and typically ask Google to provide additional information for a subset. That new data is usually for a longer time frame than first specified. Also shows users' location outside as well as inside. Finally, at step 3, officials demand the identity of a further subset, names, email addresses, blah, 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 blah. Thus, geofence warrants are designed to eventually produce a select number of identified users suspected of committing a crime, which I will balk slightly at that. It would also reliably produce people who might be witnesses. Because you know who else is also at the crime scene? The witnesses are at the crime scene, right? So not necessarily the bad guy, maybe someone who can provide us a lead. Or a victim or something. I mean, so I'll balk slightly at that sentence, but never mind. On May the 20th of 2019 at around 4:50 p.m., a man robbed the credit union. You should not rob credit unions. It's bad. The robber presented a teller with a handwritten note demanding $100,000 and threatened to hurt her and her family if she did not comply, and a warning that he had boys on the lookout. Nice. When the teller replied that she did not have access to that money, the robber brandished a firearm. You should not use firearms to demand things from people. That's bad. These and other pro-legal tips are brought to you by Uncivil Law. He ordered everyone in the bank onto the ground and forced the bank manager to open a safe and put $195,000 in the bag. The robber then left on foot. Doesn't feel like the best thought out plan, but okay. Also, people still do bank robberies? I guess. But I mean, with all the cameras and the dye packs, and people still rob banks? Okay. I guess. Local police officers responded to the scene and began an investigation. They learned from witness interviews and surveillance footage, no shit, that the robber had approached the credit union from the corner of an adjacent church while talking on a cell phone. How much? Did you not read the sentence immediately before asking? One sentence earlier tells you the number. They learned from witness interviews the surveillance footage that the robber had approached the credit union on the corner of an adjacent church while talking on a cell phone. But they could not find anything more, and the robber remained at large. On June the 14th, a police officer thus applied to Virginia magistrate for the geofence warrant. The application described the cell phone data that Google collects and describes how they do it. Success was particularly likely here, the applicant said, because the robber appeared to be using his phone and may have even been speaking with an accomplice. The officer's proposed geofence was a circle with a radius of 150 meters surrounding the credit union, which feels pretty reasonable to me. If this is turning on reasonableness, unless the Supreme Court's going to tell me otherwise, which, to be honest, they might, because I would have said, yes, it's reasonable third-party doctrine. I had my beautiful third-party stamp all ready to go. I'm not allowed to use that stamp anymore. If you're asking me to just decide this on generic reasonableness, 150 meters for 30 minutes before and after, I don't know, sounds pretty reasonable to me. So are you going to give me any further guidance, or are you just going to leave me out in the wild? I don't know, man. Let's find out. Yeah, 150 meters is a football field and a half in every direction. Yeah, that's not, especially if you're trying to find accomplices who might be nearby, potentially in a car wedding. Just because he walked out doesn't mean they didn't get in a car or something. 150 meters, football field and a half. Yeah, that feels appropriate. Yeah. 150 meters is probably the length of the stadium grass itself. I haven't measured it, but it's not, obviously the marked territory isn't the entire thing. So, and also, of course, a football field includes the end zones, and the end zones themselves are what, 10 yards long? So that's what, 120 yards. And then, yeah. So yeah, it's a stadium-ish, a stadium pitch-ish worth of territory in every direction. I can literally see the end of it. It's not that hard, man. It's not that far. Yeah, no problem. Why the court take the case? It's still a pretty big deal. I mean, you know why they took the case? I'll tell you the exact answer. They might have taken the case specifically because they wanted to make a narrow but consequential ruling, right? I had this beautiful stamp called third-party doctrine. It was beautiful. I had my rubber stamp totally ready to go, right? I'm a judge. I've got this beautiful rubber stamp, third-party doctrine. It's just itching to go. And I'm ready to just go stamp all the things. And the Supreme Court said, hey, maybe not all the time in every possible way. And the lawyer in me pops my head up and be like, wait, what now? Because this is opening the door. This is the crack in the dam, if you like. Now, where does it go from here is a whole nother set of fun concerns, right? Because then the lawyers like me start generating in our mind, okay, what's next, right? What's next? If this is true, what else is true? What's next? But the Supreme Court just opened a door that 5 minutes ago was not open. They're creating a whole world of possibilities. And depending on what they write, and we haven't gone that far yet, we're still well in the process of deciding it, they may just be opening up the door for the future without really doing anything necessarily right now. They're just teeing it up for the future. But even if they're just teeing it up, right? Even if they're just saying, hey, by the way, maybe not the stamp, that's pretty big in and of itself. Because future lawyers like myself, if we ever get to the Supreme Court, are going to quote this case like it's our favorite thing ever in the Fourth Amendment context. And we're going to say, you know, how'd you like to go a step further? Right? So this is important, consequential, meaningful. There will be seminars, and I'm not even exaggerating. There will be seminars about this case and what it means. The lawyers are going to go a little nuts trying to figure out what the hell is going to happen for the next 20 years. This is a big deal. How big a deal it is, I'm still not sure. We're still trying to find out. It's a big deal. How big a deal is, we're still working on it. All right, the warrant application process that Google will produce. Okay, then they're going to talk a little bit more about that. All right, following police work, the federal grand jury charged the guy with robbery and firearms related offenses. He moved to suppress. According to the guy, the officers had obtained that data through the Fourth Amendment search, and the warrant obtaining it was invalid, which it wasn't that day. I guarantee you that. It might be now, but it wasn't at the time. The district judge mainly agreed with the guy's Fourth Amendment analysis, but still denied the motion. Even though this particular warrant plainly violates the rights enshrined in the Fourth Amendment, district judge has some big district balls. The court stated the officers' reliance on it was not objectively unreasonable. And that was so because the court concluded the good faith exception to the exclusionary rule permitted admission of the location data. Yeah, it's never illegal the first time is definitely a thing. You know, you got to give people notice for good and ill. So like, yeah, it was wrong, but you didn't know it, so you get a mulligan. Or it was wrong, but it wasn't wrong at the time. We're just telling you it's wrong in retrospect. So you couldn't have known because it wasn't illegal, but now it is. So now you know for the future. More of the point. A divided panel. Nice to see you, buddy. Good to see you too. A divided panel of the Fourth Circuit affirmed, but on a different reason. The majority held the government did not do a search, which, yeah, or at least not one that we care about because that third-party doctrine stamp is looking real attractive. That was so because the guy did not have reasonable expectation of privacy because of the third-party doctrine. The judge dissented, holding that the police's intrusion into location history data was a search that triggered the Fourth Amendment, and the warrant was so lacking particularity and probable cause that was invalid. Okay. The Fourth Circuit has some spicy thoughts on the matter. After granting en banc, the Fourth Circuit agreed with itself. We granted certiorari solely on the question of whether police violated the Fourth Amendment and obtained the guy's location data, thus declining to consider the exclusionary rule issue. Okay. The disputed Fourth Amendment question divides. So this guy might get fucked. So this guy looks like he's remaining fucked. So bad news for the bank robber. You're still fucked. Sorry. You did do the bank robbery and all. But, if it makes you feel any better, your name is now a case, and it might help people in the future. Please keep comforted with that thought as you enjoy prison. All right, let's see. We grant cert solely on the question whether police violated the guy's rights, thus declined to consider the exclusionary rule. The Fourth Amendment divides in two parts. Did law enforcement do a search under the Fourth Amendment? We hold they did. Okay. Because an individual has a legitimate expectation of privacy in cell phone data. See, that right there is like, that's the thing. It's like, no, that wasn't the answer. I check the sheet. I have my test prep book, and I have my bar prep book, and I looked in the back of the book and everything. That wasn't the answer. Reasonable expectation of privacy. What the fuck are you talking about? I've got this stamp, man. Yeah. Okay. We leave the question which decides whether the warrant satisfied the Fourth Amendment probable cause. Okay, wait. So, okay. Second, did the multi-step geofence warrant make the search reasonable? I guarantee you, well, I actually can't guarantee that. I actually don't know what the fuck the court is going to do. The trial court seemed to say no. And the Fourth Circuit seemed to say no. So actually, I was like, oh, I can tell you for sure what the court's going to do. And I'm like, wait, no, it can't. This goes back to the same judge. He's gonna try to free this guy. This guy might get another case named after him before the end of this thing. I tell you what, man. This guy's going to be a ping pong ball for a while. In any sense, we leave the question which decides whether the warrant satisfies the Fourth Amendment probable cause in particularity to the Court of Appeals. If I'm on the Court of Appeals, I'm just like, fuck me. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The basic purpose of the amendment, as our precedents say, and there's the footnote, just to twist the knife a little bit more. In line with our grant, we do not address where the good faith still allows admission to location history. So yeah, this guy might be pretty fucked. Maybe the next guy though. But yeah, this guy sounds like it's kind of fucked. All right. The purpose of the Fourth Amendment is central. The purpose is central decisions about whether Fourth Amendment searches occurred. Our early search doctrine focused on whether law enforcement officials obtained the information by physically intruding. Because, electricity hadn't really been invented yet. But this court in Katz recognized the Fourth Amendment protects people, not places. I mean, it is an individual right, so to some degree, that's certainly true. And we've long held that property rights are not the sole measure of the constitutional violation. The Fourth Amendment protects certain expectations of privacy as well. To be fair, that is true. We could talk about the reasonable expectation of privacy of a phone booth, because that's a thing. Did you know you have a reasonable expectation in a phone booth? Your next question probably is, what is a phone booth? And we don't have time for that. When an individual seeks to preserve something as private as expectation privacy is one that society is prepared to recognize as reasonable, then government intrusion in that sphere generally qualifies as a search. Okie dokie. Whether an expectation of privacy counts as legitimate is less the result of any fixed set of rules than guideposts stretching back to the Fourth Amendment. By the way, just out of raw curiosity, how is the gain on my microphone? I'm not concerned about overall volume, but are you picking up too much like ancillary noise and stuff? And should I turn the gain down another notch? I'm open to your suggestions. Where were we? Sounds good? Great. Excellent. Okay, good. Excellent. There are a lot of electronic filters in place to make my voice sound good, but we do like to check these things from time to time. Moving forward. The electronic filters aren't perfect. They're electronic, but they help. From the founding onward, we've explained the Fourth Amendment sought to secure privacies of life against arbitrary power, and citing Carpenter. So recently recognized which dealt with whether a cell phone was a container, which was less of a shocking decision, to be honest. Whatever the form of the attempted incursion, nice word choice, incursion. The Fourth Amendment protects Americans' long-held conviction that no government official should have free access to most closely held aspects of our lives. This feels very left-leaning. Who wrote this? Gorsuch? No, this is Kagan that wrote this, right? This feels like Kagan. Feels like someone on the left definitely wrote this. Okay, fair enough. In recent decades, the court has often confronted the challenge of adhering to its principles in face of new technologies. Fair enough. Innovations in surveillance tools have enhanced the government's capacity to encroach upon areas normally guarded from inquisitive eyes. The court in response has sought to assure protection of the degree of privacy against the government that existed when the Fourth Amendment was adopted. So in one decision, we rejected a mechanical interpretation of the Fourth Amendment to hold that use of thermal imaging to detect heat coming from a person's home was a search in a constitutional sense. Well, one, the home, right? So the home has always had special Fourth Amendment protection. So there's that. And two, the heat being radiated out into the world isn't really voluntary. Like, it's not like you can really do much about it. So that was, fair enough as far as it goes. And another, we held that search of a cell phone instant arrest could not proceed without a warrant because the cell phone is itself a container. And once you treat the cell phone as a container that has to be searched, then it makes a lot more sense. More recently in Carpenter, the court held that accessing a form of cell phone location information other than location history is a Fourth Amendment search given individuals' reasonable expectation of privacy. But Carpenter dealt with a physical intrusion onto a car. We begin with Carpenter in considering the government's frontline position that no warrant was needed to get location data, although the police prophylactically secured one. You gotta love that choice, prophylactically. Nice word choice. Does pop up in cases from time to time. I mean, you got to put on a condom if you're going to fuck, right? Because no Fourth Amendment search ever took place. We then explain why the result we reached in Carpenter once again follows. Contrary to the government's view, an individual has a legitimate expectation of privacy in the information location history collects about a cell phone, meaning its own movements. The police invade that expectation and thus conduct the search when they acquire that information, even for a limited period of time, even though through third-party tech. The question presented in Carpenter is whether the government conducts a search under the Fourth Amendment when it accesses historical cell phone records that provide a comprehensive chronicle of the user's past movement, incidentally in possession of a third party. The cell phone records at issue are whatever, they're timestamped, blah, 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 blah. They can help law enforcement. That's great. The court begins by reviewing what it said about different physical tracking. United States versus Jones, 5 justices agreed that tracking counts as a Fourth Amendment search because individuals have a reasonable expectation of privacy in their physical movements. Citing Carpenter. That makes sense, the Supreme Court thought, even though movements occurred in public. Okay. Prior to the digital age, pursuing a suspect for any extended period of time was difficult and costly, and therefore rarely undertaken. As a result, society's expectations have been that law enforcement agencies and others would not, indeed in the main simply could not, securely monitor and catalog every single movement of an individual's car. Okay. A new technology should not transform what individuals had reasonably thought they could withhold from the government. Okay. It follows a fortiori, Carpenter held, that allowing government access to cell phone records contravenes expectations of privacy. To an even greater degree than cell phone monitor or GPS monitoring, relevant data can provide full records of holders' whereabouts and with an intimate window into a person's life. People, after all, regularly leave their vehicles, but they compulsively carry their cell phones at all times. A cell phone thus tracks nearly the exact movement of its user. It faithfully follows him not only through the public, but private, doctors' offices, political headquarters, and potentially revealing locales. Very saucy. What is more, the newfound tracking capacity that the relevant law gives, the police runs against everyone, not just those under investigation, which, fair enough, but that's not necessarily a bad thing because, witnesses and stuff. So the fact that it reveals innocent parties isn't necessarily a bad thing. The police would like to find the witnesses to the crime, don't you know? And travels back in time. Kagan does understand that the police don't necessarily just want to find the bad guy. They might want to find witnesses to the bad guy. And okay. Police officers need not decide in advance, as they do with GPS, who they want to follow and when. Instead, they can easily and cheaply, just with the click of a button, reconstruct any person movements retrospectively. Yeah, the breadcrumbs are real. What the past was unknowable suddenly becomes open to view, presenting further unimaginable privacy concerns. The court thus concluded when the government accesses this data from wireless carriers, thus obtaining a detailed log of where Carpenter had gone for 7 days, it invaded Carpenter's reasonable expectation of privacy in the whole of his physical movements. Carpenter itself was a pretty big deal, to be honest, because that also did a pretty big thing in the third-party doctrine. When we tried to get cell phone records from the wireless company, and Carpenter was a pretty big deal too. And this is also a big deal. This is another blow, another hole in the wall. What does it mean for the future? Seminars will be written. The relationship between these data and the relationship of personal privacy practically leap off the page. Everything Carpenter relied on to find law enforcement when they searched the wireless records, Google too. And, pretty much, it pretty much was the same in when you kind of boil it down. The government said, give me the cell phone records from the wireless company. Why? Very comparable reasons. I have no problem with the comparison. It's fine. Nothing about the situations are materially distinct. Location history provides an even more fine-tuned picture of a person's movements than the relevant law. Carpenter noted that through the relevant records, police could achieve near perfect surveillance of an individual holding a cell phone. But location history is nearer perfect still. Here's one way of comparing the two. Oh, Lord, the Supreme Court's going to do technology now? Hold me. At any given time, the relevant cell phone data placed Carpenter within a sector, ranging from 1/8 to 4 square miles, whereas location data pinpointed location with around 20 meters, which is less than 2% of a mile. Okay. Or here, another measure. The cell phone location data from the cell phone company logged Carpenter's location an average of 101 times a day, whereas location history commonly records a person every 2 minutes, for a daily average of 720. Yep. Or finally, a third. Unlike cell phone location data, location history can estimate a phone's elevation, sometimes. So, for example, it can tell where someone has gone into a doctor's office on the first floor of a multi-story building or a private apartment on the 10th. Sometimes, if you're lucky. GPS isn't necessarily great indoors. Although there might be other clues from Wi-Fi and stuff, but still. Where were we? Okay. Of course, the accuracy of each test technique may vary in different places in time, but across the board, location history is a far more precise measure. Sure. It's at least as good, which, to be fair, is kind of all we need, right? It's at least as good as, we don't need to, there's no reason to make it more accurate, right? We don't need more accurate for the legal conclusion. At least as good will be just fine. If it was less accurate, we might have to have a talk about it. But as long as it's at least as accurate as the precedent, why are we spending the time distinguishing? Who cares? It's at least as good. So horseshoes and hand grenades and nuclear weapons, you know what I mean? And next, location history also allows police officers to reconstruct retrospectively and with no real effort people's comings and going. As with the cell phone data from the cell phone company, the government need not decide in advance the kind of surveillance it should undertake, whether a person of a site. Whoever the suspect turns out to be, he's been effectively tailed every moment of every day. Facts. But likewise, as this case shows, whenever a location of interest turns out to be a crime scene or a protest march or even a private home, has effectively been surveilled for the same boundless time. That's very poetic. Ennio's going to write a song about it. Google's location history will be available to chart the moments of many individuals, or few or one, within the vicinity against the click of a button. It's not quite that simple, but okay. Recall that in Jones, it was thought notable that law enforcement officials of an earlier age usually cannot monitor every movement of an individual car, as GPS does. Far less could these officials ever perform tireless and absolute surveillance of any number of people in any number of places, public or private, the location history can accomplish. I mean, how does this relate to flock cameras is a reasonable question now. I don't know. Are flock cameras legal? I don't know. I mean, in that case, they're being produced wholly by a third company without the participation of the user. Like in the case of a cell phone log, you're making the calls. In the case of this, you're carrying the cell phone around. So you yourself are carrying your bugging device, namely your cell phone. In the case of flock cameras, a company, without your knowledge, permission, or participation, except to the extent you're driving. Are flock cameras legal? I don't know. That's definitely going to be an argument someday. Look forward to that Supreme Court argument about 5 years from now. Moving on. Location history implicates those privacy interests still more than CSI. And then, of course, the case that I don't know when it's going to happen, and neither do you, but someday, somewhere, they're going to automate some of this detective work with AI. To the extent it hasn't already happened. The difference, of course, is going to be that the government will admit to it. Someday, somewhere, AI is going to be conducting the search. And then we'll have to decide about that. So look forward to that case, let's say 8 years from now. Keep that on your radar. Okay, location history implicates those privacy interests more than the cell phone data because the former is more of an individual's own. Most cell phone users have no awareness that their cell phone company keeps records. That's probably true. And anyway, would never try to retrieve them. The records are instead the province of the wireless carriers, which maintain them for an array of business functions. No doubt Google itself uses these records to improve the quality of its apps. That's one way of putting it. Sure. They're doing it for app quality. Sure, let's go with that. But Google users too regularly employ location history to remind them of a restaurant they ate at 2 weeks ago, the time they were last at a friend's home, the sites they saw on vacation, or a distance they walked a particular day. The records thus serve a personal journey of a user's movements, which that user consults and even can edit for their own purposes. In that way, location history, documents, photographs, or calendars, even stored on Google servers, a user reasonably views as their own. Okay. As a result, that he reasonably expects to be shielded from inquisitive eyes. Yeah. I mean, I don't know how a right-leaning person writes this decision. I'm not necessarily opposed to it, but this is definitely a left-leaning decision because this is some living constitutional shit right now that's happening. And so, yeah. The government, not much contesting any of the above, principally argues on different ground that accessing only a short amount of cell phone data does not count as a Fourth Amendment search. It has to, though. That doesn't make any sense. Yeah, that doesn't work, right? Just the tip, though, that doesn't work as a Fourth Amendment argument, right? That as to whether it's a search at all. Now, whether it's a reasonable search is a whole other set of problems. But if I'm the police and you are a business and you have a lot of filing cabinets because you're old school, right? You're old school and you do paper because you believe in it, because you don't trust technology or something, right? So if I'm a cop and I, without a warrant, come into your place and I start rifling through all the many papers, right? That's one thing. Now imagine that instead of doing that, I, the police officer, without a warrant, come into your place of business and I very calmly open one drawer and remove exactly one file. And my argument is, I didn't do a search, Your Honor, because I didn't remove that much stuff. See, that doesn't really work, does it? I only removed one thing, Your Honor. That's not a search. Okay. It might be a reasonable search, but to say it's not a search at all is some bullshit. The dissent likewise contends that the duration data here is too brief to a search have happened. Yeah, that doesn't work for me. That argument I don't buy. I was only looking for a little bit, Your Honor, so that just the tip doesn't count is not working for me. I'm not really buying that argument. Recall that Carpenter involved 7 days worth of location data. In deciding that, the court decided whether there was a more limited period from which the government may obtain such data free from Fourth Amendment scrutiny. The government now claims the answer is yes, and that 2 hours worth of location history falls within the Constitution-free zone. Yeah, that was a problem in Carpenter right away. If 7 days worth of data is a search, how is 1 day worth of data not a search? It might be a reasonable search, but how's it not? Okay. But the Supreme Court didn't want to answer that question because, of course, they didn't. Anyways, moving on. In the government's view, a person has no reasonable expectation of privacy in a short time window of location data because his short-term movements will reveal little about the details of his personal life. If that short time involved a visit to a sex shop, they might have some thoughts on the matter. The government cites in support of United States versus Knotts, in which the court held that government's use of a beeper to assist hours-long trail of a car did not bring the Fourth Amendment into play. The lessons the government draws that law enforcement officials' location history should receive a Fourth Amendment grace period of some number of hours. Yeah, no, the conservative in me is like, fuck no, right? I'm like, I don't know what the answer is, but I tend to think categorically, right? I tend to think in categories and in boxes, if you like. I tend to think in boxes and be like, just a little bit though. I'm like, get the fuck out of here with that argument. And like, that is not working for me in conservative land either. So now you're pissing the conservative in me off just a little bit, bro. Go fuck yourself. But to begin, the government is wrong about the incapacity of short-term location information to reveal private matters. Repeat patterns of the government's phrasing are not individuals' wish, reasonably expect to keep for themselves. Thank you, Tread, for being a member for 32 months. That is very, very thoughtful. Thank you. We do appreciate all the super chats. And if you give a super chat, I might like you a little bit more, maybe. Maybe you'll be my friend. Why is your name not in green, for example? Do you not like me? It's 99 cents a month, man. I know it's a bit, kitsch for a YouTuber to be like, hey, don't you have $1? But I mean, still, like, I do try to keep it to a minimum, man. It's like 99 cents. You can't even buy a hamburger anymore on the dollar menu for that shit. Like, man, you can't buy a cup of coffee. I have a good deal over here. It's 99 cents a month. Give me $1. You know the phrase, I'd buy that for $1? Just saying, man. Even short-term monitoring of physical location movements can provide a wealth of details about familiar, political, professional, sexual, and religious associations. Consider a few trips a person thinks is indisputably private to the psychiatrist, the plastic surgeon, the abortion clinic. Okay. I have to say, did you really have to bring the abortion clinic into this, Kagan? You couldn't help yourself, could you? You just couldn't help yourself. You just had to slip in the abortion clinic into the list of examples? Why? You're doing so great with doctor's office. Why did you have to slip in abortion clinic? You just had to get that in there, man. Thank you, Shouting Into the Void, for your uncivilian membership. The AIDS Treatment Center, the strip club, the criminal defense attorney, or the by-the-hour motel. And unlike a GPS device, location history enables police officers to focus precisely on those sites to see the given time block who show up. Similarly, location history, even 2 hours of it, allows officers to target one-off events, such as a gun show. Ooh, a little meat for the right. A little meat for the right. Maybe they're coming after the people who go to gun shows. You like that, conservatives, don't you? Ooh, a little right-wing meat. Okay, I'm here for it. That's fair. Still more fundamentally, we've never understood Fourth Amendment protections as kicking in only once the intrusion goes too far. Facts. When Fourth Amendment applies, it applies, regardless of the quality or quantity of the information. Yeah, I mean, no shit. Just a tip, bro. What the fuck are we even talking about? So, for example, this court held thermal imaging quality as a search, even though it does not, and likely to detect private activity or intimate details. The amendment we analogize makes no exception for the officer who barely cracks open the front door and sees nothing but the non-intimate rug on the vestibule floor. They wrote that? The Supreme Court wrote that as an example, and now they're quoting themselves? I don't know about that example, ma'am. I don't know about that example. And likewise, the amendment does not give agents a pass if their wiretap is of limited duration and thus likely to intrude on private matters. Indeed, in our wiretap cases, the police obtained only 18 minutes of record. I'm surprised they didn't bring Nixon's missing tape into this thing. That approach makes all the more sense when, as location history, officials can select the time limit of materials they want from an all-encompassing database. Thus, the durational bounds on the activity acquired have little to do with the Fourth Amendment, about too pervasive as it relates to permit police's surveillance. What creates that concern is the government can access all the cell phone user movements, in both public and private, that possesses a virtual panopticon, nice reference, with which to scrutinize its citizens' activities. The sweep of an official investigation is not made less because the government, with benefit of hindsight, can pinpoint exactly which few hours of movement it wants to review. The feature of accessing location data is indeed more practical benefit to the government than a limit on its intrusive powers. Okay. And contrary to the government, Knotts does not support the view that accessing 2 hours is not a search. There, the police officers put a beeper in a car to help them follow it from Minnesota to Wisconsin. The court decided the beeper did not turn the tail into a search. They would today because they'd say it's a physical trespass, but never mind. But it was explicit in keeping its holding cabin to that rudimentary technology. The defendant had argued that the ruling against him would enable officials to conduct surveillance of any citizen in the country free from the strictures of the Fourth Amendment. The court took the concern seriously, stating that if technology progressed so as to allow more sophisticated surveillance, different constitutional principles could apply. Well, I'd say it differently. The same constitutional principle to a different set of facts, but whatever. $10 from Tread, 1775. Hey, smartass, lol. I gifted 50 the other day. It also said I wasn't a subscriber. I gifted 20 just before my anniversary post today. Well, thank you very much. I appreciate your donations and thoughts and your contributions to the cause and your thoughtly money. Your thoughtly support. All right, we're away. 3 decades later, 5 justices and 2 opinions found they did. When Jones, with the GPS device, which unlike the beeper involved remote monitoring, they decided notwithstanding costs, the privacy was implicated. Physical trespass, as memory serves. And even that was not all. But 6 years further on, Carpenter Court held that cell phone data was a search. It recounted to Knotts to Jones progression, explained why Knotts did not stand in the way. For a third time, we reached the same conclusion today. Okay. And still another feature of Knotts made it inapt here. You know, I think I think I'd underestimated the impact of Carpenter when it came to this. This decision is less surprising in light of Carpenter. Still surprising, but still, it's like, it's still a pretty big deal. But I suppose Carpenter was the bigger deal in to be constitutionally precise. This is just more furthering and extending Carpenter than more of a revolution, but still a big deal. Another feature not made inapt here, the surveillance there was confined to public roads. The fact was crucial to the court's decision. A person traveling an automobile on public thoroughfares has no reasonable expectation of privacy because the court is in plain view. By contrast, the movements of location history reveals are not limited to public streets. A cell phone faithfully follows its owner beyond public thoroughfares into private residence, doctors' offices, and political headquarters. You're not going to mention the abortion clinics again? In one of those places, a private residence, this court has held that even beeper technology could reveal whether a particular article or person from the night was in the home at a particular time. And the home is special in the Fourth Amendment domain. So there's that. If so, accessing location history must be a search, even only for 2 hours, because the data can be far more reliable than someone within a home. The government replies with an odd argument. It thinks that tracking someone into a private residence, yes, even for 2 hours, would probably be a search, but it tells us not to worry about it because this guy didn't go home. Yeah, that's a little bit thin. That approach is foreign to the way the Fourth Amendment works. Not totally foreign. The home is special is totally a Fourth Amendment argument. May not be totally satisfying here, but the home is special is not. It's a trump card for a reason. Whether something is a search does not depend on what it finds. That's true. A search can reveal nothing and still be a search. Just because the police didn't find anything doesn't mean they didn't search. That's true. An officer, after all, cannot know the fruits of given surveillance in advance. The surveillance must be either in search or not, regardless. The government concession thus gives away the argument that for the purposes of the Fourth Amendment, 2 hours is not enough. Yeah, that doesn't work for me as a conservative. Yeah, I don't like that argument as a conservative. With a conservative, I'm like, get the fuck out of here with that argument. The government has an additional argument, which in Carpenter was the primary one, that the so-called third-party doctrine, and this is your big boy, right? Third-party doctrine is your big stamp. Do I get my big stamp, Supreme Court? Precludes him from invoking the Fourth Amendment. And the dissent, unsurprisingly, says, how about the stamp, though? Which is totally non-surprising. The idea is in that authorizing Google to collect, retain, and use his information nationwide, the guy lost expectation of privacy and therefore his right to complain about the search, regardless of whether it was 2 hours, 2 weeks, or 2 years. That would logically hold. That's true. That's how categorical thinking works. Yeah, 2 hours or 2 years are equally good because category, yo. The problem for the government, and presumptively the reason for its primary assertion in Carpenter here to become a secondary one, is that Carpenter refused to apply the third-party doctrine, and no good reason exists to reach it differently. Fair enough. I mean, that's fair. So third-party doctrine is looking a bit shaky in light of modern technology. The Supreme Court doesn't feel like it really wants to go to the end of the page yet, which isn't surprising because law is still small c conservative. So we tend to act in small steps. But between this and Carpenter, the Supreme Court is indicating maybe third-party doctrine isn't absolute after all. Now, how far does that go is the question. If you'd like an answer to that question and you have a case, give me a call and I will help answer that question for what will probably be the low cost of about $250,000 by the time we're done through all the stages of trial and appeal and everything. So if you'd like some answers to that question and you got a case in $250,000, give me a call. You need my professional opinion on a civil matter. I don't know anything about the case. I don't know anything about the case. If you want an analysis of an opinion, and you have a particular opinion you want me to review, I'll do that for $100. So if you send me a copy of the opinion and let me know you're willing to pay $100 for a review of it, I'll do an analysis of it. Let's see. The positor, the court explained, had taken the risk in revealing his affairs to another that third party would turn to provide the information to the government. A few years later, the court in Smith said applied the principle of hold that a landline telephone subscriber lacked legitimate expectation of privacy in the phone numbers he dialed. Once again, the court reasoned the subscriber had voluntarily conveyed the dial numbers to the telephone company. Yep. In Carpenter, however, the court rejected the government's contention. Third-party doctrine likewise governed the acquisition of the cell phone data. The court acknowledged that cell phone users continuously reveal their location to a third-party wireless carrier, but held that cell phone location number is qualitatively different from telephone numbers, or location is different from numbers and bank records. Okay. Those differences fall in two areas. First, the court explained the nature of it is comprehensively and comparably revealing. There's a world of difference between exhaustive chronicle of information casually connected by a wireless carrier, and limited types of personal information addressed in Smith and Miller. The former implicates privacy concerns far beyond the latter. If you get 50,000 members, will you do a Supreme Court case pro bono? Well, that'd be $50,000 per month. So, sure. Yeah, if I get 50,000 members, yeah, that sounds like I could take on some cases pro bono to me. Sure, I can work with that. Both differentiating features required highlighting Carpenter applied equally or better to location history and noted above. Location history is even more revealing than cell phone data because it provides a yet more precise record of individual movements. Access to that record enables officials to undertake nearly perfect retrospective surveillance of countless persons and places. Access to that record, okay, for location history, that surveillance is based on information the user reasonably understands as his own, even though Google stores it much like his email, phones, and calendar entries. Likewise, the information is not truly shared in the normal sense of wanting a third party to see it. That's a very good point. So that is her strongest point to date. That's her strongest point to date. It's not third party because it's not something that we're trying to make public. It's something that we don't try to, that we typically don't expose. So it's not public. That's her best point so far. So I like that. The exposure of that information to Google is merely what happens when a user avails himself of one of the services on the cell phone. Or said a bit differently, it's automatically the price of conventional cell phone usage, which, just as Carpenter noted, is pervasive and insistent. So the third party does not apply there, it does not apply here. I appreciate that as logical follow through. I have no problem with that. You could question the underlying decision in Carpenter. But given Carpenter, this case is not surprising. It's a little surprising still. I mean, it is a significant, well, it's a significant add-on to Carpenter. So it's still pretty significant. But if you accept the premise of Carpenter, this flows logically. This data is at least as accurate and at least as sensitive as Carpenter, right? So if it's at least as accurate and at least as sensitive, right, there's no reason for the same rule not to apply. That's categorical thinking, right? It falls within the bucket. If Carpenter defines the bucket, this seems like it fits very well within the bucket. So the conservative in me is pleased by that. I have no problem with that. That I can work with. The problem with Carpenter is the 7-day thing, because even the Supreme Court said, well, 7 days is too much, but we're not going to decide about other things. And that makes the conservative in me grumpy, because it seems very odd that if I'm searching for 7 days worth of cell phone location data, somehow that's not okay. But if I'm searching for 7 minutes worth of cell phone location data, suddenly that becomes okay again? Isn't the 7 minutes still a search? Isn't it the equivalent of going into the business and rummaging through all the files and all the filing folders versus going in with precision, picking out one specific thing? It seems to me. So the 7-minute thing makes me grumpy as a conservative. But given Carpenter, I have no problems with this, putting this in the same bucket. And there is precedent, such as the phone booth thing that precedes this, that supplies some intellectual support, although the extension is more aggressive. But at least there's some precedent in the prior case law that supports, if does not lead to, such a proposition. The government contests the conclusion Carpenter's second axis. It claims that generating location history, unlike the cell phone data, is voluntarily choice. Although carrying a cell phone may be indisputable, the government argues using location history is not. Rather, location is additional add-on, which a user must enable. In support, the government emphasizes only around a third of Google account users have activated the service. That goes to show that people can live without the location history. And if true, people who do use the feature have indeed voluntarily exposed. That's a pretty good argument for the government. It's opt-in and they've opted in, and with the bitter comes the sweet, with the good comes the bad. That's not a bad argument for the government. And that's distinguishable from Carpenter because, cell phone company is going to collect your cell phone data, but you don't have to give Google anything. That's a pretty good argument for the government. I like that. But as an initial matter, that argument ignores some pertinent facts about how and why Google users turn on location history. Google prompts the user and repeatedly to turn on the service when he sets up the Google account, when he sets up an Android phone, and when he sets up the Google app. The prompt often informs him his device will not work correctly. By contrast, it does not quite tell him what he's signing up for. So the consent isn't valid because it's not real consent. I can work with that as a conservative. You need it to be voluntary, intelligent, and knowing for it to count as consent. And it's not, so it doesn't count. I can work with that as a conservative. It's not really consent. I can work with that. Not quite telling what he's signing for, how frequently they record, how precise location history could be, or how Google might tell all the minute-by-minute location. Is it helpful to you for me to say, in this liberal opinion, here's how conservatives might think about it, or here's how at least this conservative might think about it, or here's how this conservative might agree with these? Is that helpful to me for okay, this is definitely written by a left person. Here's some things that are left-leaning, obviously, but there's some things in here that a right person can get. Is that helpful? To show you how conservative principles or conservative legal principles can lead to at least comparable conclusions? Does this open Google to issues? Not really, maybe, but not because of this. I try to it helps to explain different modalities of legal thinking, right? It's here's this opinion's written by a left-leaning person. Here's how a well-educated left-leaning person would think about it. Because Kagan is very well-educated. She's by far and away my favorite person on the left. Here's how a well-educated left-leaning person might think about it. With who's intellectually honest and actually thinks about this from principles and has a brain in her head. I may not agree with Kagan because I disagree with a lot of her priors, but she's intelligent and thoughtful. So here's how a well-intentioned, good faith, left-leaning person might think about it. Here's elements of it that it can appeal to the right. I don't know. It's hard to see how any user in the normal sense sharing with third parties comprehensively catalog a third party movement. And so that regardless of how many others ignore Google's entreats. How do you pronounce this word? Is it just pronounced entreats? IES? I guess it's pronounced entreats. It just doesn't look like it's pronounced that way, but I can't think of how else that word would be pronounced. It must be pronounced entreats. Okay, fair enough. Okay. The government estimation of the numbers almost surely overstated. It appears to include, for example, the many millions of Google account holders in foreign countries where collecting location history is illegal. Okay. But in any event, the raw user totals for location history, 1/3, 2/3, or somewhere in between, are not the most apt measure, as governments self-consciously assume the risk of sharing all their movements with others. Entreaties, you think? Okay. Thomas is your favorite? I don't like Thomas. Yeah, I don't like Thomas. No. He makes a number of decisions. I can't quote you chapter and verse off the top of my head, but more frequently than I'd like, he makes decisions that I don't find to be particularly conservative. So I don't like Thomas. Gorsuch is my man. More generally, the government approach to the Fourth Amendment was raise a host of workability issues. At the top of the list, what percentage of users would sign up for the service, doing so make it non-voluminous. The government pointed an argument that 80% of active Google users had enabled location service. The case would be much closer. After all, the government candidly noted even possessing a cell phone is not truly indispensable. I suppose. I mean, the Amish don't have cell phones. I don't think. I don't know enough about the Amish. And there's a lot of different kinds of Amish. Probably shouldn't say things like that. It's not truly indispensable. So where to draw the line? After that, the questions only multiply. Would a user lose the Fourth Amendment protection of a highly popular cell phone feature became less so over time? Yeah, this is dangerous. Looking to like this kind of thing is dangerous. Although it does go with reasonable expectation of privacy. So yeah, this is Kagan a little bit trying to have it both ways in a way that is a bit dishonest, right? With the good comes the sweet, with the bitter comes the bad. Like you can't kind of have it both ways. I think rules should apply. That's my thing, right? A rule should apply both ways evenly, right? So if you want to say, okay, cell phones didn't exist at the founding and people they act in a way that shows their belief that it is non-public or that they have a reasonable expectation of privacy. If that's true, then but it isn't a one-way ratchet, right? If people act differently or they decide differently or they treat it differently, then the Fourth Amendment protection would go away, right? Because if it's based on the collective reasonable expectation of privacy, if people collectively decide, you know what, we don't really care very much that people know where we go and all the rest of it. I want to share all my data all the time, which, to be honest, sounds ridiculous until you think about it for 5 seconds. It's like, geez, no one would share all their location data with everyone all the time voluntarily. It's like, have you met TikTok? It's probably a trend. You know what's going to happen, right? You're like, no one would do that. I'm like, not only will they do that, it's going to be a TikTok trend. People are going to just be sharing all their location data with all their friends all the time. It's going to be a whole thing on TikTok. There's going to be 100,000 people share all their location data. You know it. I know it. Let's not pretend it's true. Not true. We all know this is happening. When, I can't say, but it's definitely a thing that's going to occur because people are fucking morons. You know, on a totally unrelated topic, I think I've made this point before, but it just crossed my mind for whatever reason as we were talking about idiots. I do like those people who go out into the field and like ask people like basic questions and then they don't know the answer. But my personal favorite question that these people ask is, who fought in the Civil War? And I'm just waiting for someone to say back which one. It hasn't happened yet. But I'm just waiting with bated breath. Somebody respond to the question, who fought in the Civil War with which one? Please, somebody do that. I'm waiting. I have hope. Would a user lose Fourth Amendment protection if a highly popular cell phone feature became less over time? Maybe. Finally, a more basic inquiry. In such a world, has anyone, whether cell phone user or police officer, know in advance whether enrollees in a given service will be found to have Fourth Amendment protection information? I don't even understand 100% the question. That's a very odd question. Yeah. There are multiple countries that have had a civil war. Yeah, it would be a shorter list to name which countries haven't had a civil war. That's the thing, right? Yeah. Which countries have had a civil war? Which countries haven't had a civil war? That's a more interesting trivia question. Which country has not had a civil war? I don't even know. I'm not 100% sure there is one. Vatican City, maybe. But even then, I don't know, man. They've had conflicts over popes and shit, although they necessarily haven't gone to war over it. Or did they? It's been a while. There was the whole Papal States War. I'm not even sure Vatican City. Is there a country that hasn't had a civil war? Get back to me on that one. Yet even a deeper problem. The government's app-by-app, feature-by-feature method of granting Fourth Amendment protection misapprehends the very nature of modern cell phone use. Pretty much everything a person does with a cell phone requires some sort of opt-in. Consider sending an email on Gmail. Google probably loves the brand recognition. Do you think Google's upset they didn't get their little circle TM? Didn't get their little circle TM? Sad. Australia never had a civil war? Canada and New Zealand? Okay. Yeah, I can't think of a Canadian civil war, so fair enough. Canada, they haven't done civil wars, but they keep inventing new war crimes. So Canada, not so famous for the civil wars. Canada, more famous for creating new clauses in the Geneva Conventions. Consider sending an email to Gmail, uploading a photo to Google Photos, or adding a calendar entry. None happens solely by dint of phone operation. Each requires, as location history does, additional add-on. Is the Revolutionary War a civil war? That's a good question. I never really thought about it. I guess. But we won, so we don't call it a civil war. Yeah. I guess you don't call it a civil war if the faction wins, right? Because like there was the English Civil War, but they didn't really win in the end. So we call it the English. Yeah. I guess that's the test. Does the rebellious side win? If so, we don't call it a civil war anymore. We call it something else. So yeah. So in order for it to be a civil war, I guess the rebellious side has to lose. Barrett is the traitor, worst Supreme Court pick ever. That's a little harsh. And when it comes to the ballots, when it comes to the postmark thing, I haven't read the decision. I might read the decision. I skimmed the head notes, and I might disagree with it. I haven't really gotten that far yet, to be honest. I haven't decided whether I agree or disagree because I haven't really read it because I was skimming it, trying to explain it. What I can say, it's a very narrow decision. So the right needs to calm the fuck down a little bit. It's very narrow. as far as it goes. So calm the fuck down. So is she a traitor to the cause? Yeah, I don't know. She's very smart though, but yeah. The Revolutionary War was really a real world war? Well, I don't know about the Revolutionary War, but the 7-Year War was definitely a world war. I mean, the 7-Year War should just be called World War Zero or something. I don't know. That was a fucking civil war, or that was a fucking world war. That was everyone versus everyone. I don't know. I don't know how we name these things. She's always on the wrong side of 5-4s? Maybe. Fair enough. I don't really have a strong opinion about Barrett. Gorsuch is my boy, and I do disagree with him from time to time. I may love him, but it doesn't mean I think he's God. So, yeah. Although there's a very decent chance he writes the Birthright Citizenship case. So, a lot of people on the right might be very pissed with him. The government wishes to disconnect all those users from the mere act of carrying, blah, blah, blah. For all those reasons, we hope police officers invade cell phones, reasonable expectations, blah, blah, blah. And then I'm just going to skim as to the aspect of reasonableness. So now that we've read the part they actually decided, let me read their musings on the rest of it. Okay. Probable cause, blah, blah, blah. Warrant here was uncommon multi-step 1. First step laid out the blah, blah, blah. Parties have consented legality of each stage, contested legality of each stage, blah, blah, blah. We leave all those questions to the Court of Appeals. So of course we do. Yeah, you're not going to help me out. You're not going to provide me any useful guidance, are you? You're not going to provide me any useful guidance. That's just great. Thanks. Really appreciate that. I'm as the spokesperson for the Court of Appeals. Let me just say I'm really happy right now. That's great. Super, super wonderful. Thanks for giving me absolutely no useful guidance whatsoever. I'm sure I will fuck it up. I know I'm going to fuck it up because no matter what I say, I know it's going to be the wrong answer. That's the only confidence I have in this world as the Court of Appeals. So that gives me a certain assurity. I know that no matter what answer I come up with, it's going to be the wrong answer. So I'm just going to do my best and know that I'm wrong. And that's okay. I'm going to get my teeth kicked in and then called an idiot, like I should have known better for some reason. That's fine. Okay, blah, blah, blah. In his famed dissent, Brandis, we did a wiretap as a search. Okay, all right, wiretaps are searches, noted. Brandeis said that. Okay, I'm not, why is this paragraph here? I really have to ask this question. Why is this paragraph here? Why did we suddenly take an unexpected dip into what Justice Brandeis wrote about wiretaps? Why did we take that detour? I don't know. Moving on. Wiretaps are searches. Noted. Moving on. The court in Carpenter, blah, blah, blah. Today's decision, blah, 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 blah. Okay. So they say it's a search, and they've given the Court of Appeals absolutely no useful guidance on what to do about it. That's great. That's great. As the Court of Appeals, let me just say, fuck my life. That's what I have to say. Fuck my life. You've given me absolutely no useful guidance about it whatsoever. Except Brandeis said that wiretaps are searches. That's the most useful thing you've given me. So it was a search. Okay, cool. Was there probable cause and was it reasonable? What do you want me to do? Just I don't know what you want me to do as the Court of Appeals. That's what I'm thinking. I don't know what you want me to do. Just fuck my life. And I know whatever answer it is, it's wrong. Is this guy going to get out of jail or not? Am I supposed to free this guy? And what are we doing? What am I doing over here? Anyone help me out? I got no idea. Fuck my life is all I have to say. All right. Fantastic. All right, so let's read these. Let's start with Trump versus Cook dealing with the Federal Reserve. And see if we can figure out what Trump can Trump fire people. So we got two cases. We got two cases on can Trump fire members of the executive branch. Okay. Let's read case number one. Can Trump fire a member of the Federal Reserve? Okay. The government's application is denied. The government has not shown that it's likely to prevail on legal arguments in its stay. This is an injunction, technically. Okay. Accepts the government's position would in fact transform the Federal Reserve for cause protection into an at-will employment. Interpretive step leap out of step with the statute Congress enacted and our nation's tradition of central banking protected from political interference. So, bankers are special, I guess, is the case I'm learning. So Trump might be able to fire people, but not bankers. They're special. Okay. All right. The government contends that the president's determination of cause is wholly unreviewable because the statute commits determination to the president. The court sees no such commitment. Whether a governor should be removed for cause is a decision only the government can make, but does not mean that he may make that decision for any reason or no reason. Even where statute delegates discretionary authority to the executive branch, a court must interpret the statute and affects the will of Congress subject to limits. Looper Bright Enterprises. Okay, I mean, I'm as fan as anyone of the death of Chevron, but not 100% sure what it's doing here, but noted. As the government eventually acknowledged, it falls to the courts to discern the boundaries of the president's power under the Federal Reserve Act. Unlike the government, the court sees no indication that common law forecloses all judicial review of removals. The sufficiency and reasonableness of causes of removal are questions for the courts. This has been settled law ever since the Baggs case, 1615. Holla. By Koch, Chief Justice. The cases where the government cites for contrary views are distinguishable because they address statutes that specify not only courses of removal, but procedures, which reviewing courts interpret to be exclusive. Even the president's determination is judicially reviewable. The government contends cause sets a very low bar, one the president has easily cleared. Cook, by contrast, argues that cause sets a very high bar the president's failed to meet. The court rejects both parties' positions. Everyone's wrong. I love it. Congress enacted this statute against a backdrop of the common law. Okay, so, all right, so are we trying to argue like, I'm interested where this is going. Interpreting the statute in light of the common law, I understand. Are we going to try to like interpret, I mean, to some degree it makes sense, but also, wow, are we going to try to interpret Article 2, Section 1 in light of the common law? So when it says the president is the head of the executive branch, is there going to be an asterisk because common law? Is that where this is going? Okay. Such that the court must look to the common law to decide what cause is. Okay. For present purposes, it's sufficient to observe that any definition of cause in this context must reflect the Federal Reserve's unique history, status, and role. Federal Reserve is special is basically where this is going. Federal Reserve is special. Okay. Like its predecessors, the Federal Reserve operates at a deliberate remove from ordinary political process, including a budget free of congressional control and policies not only by governors, but also representative private parties. That sounds like a problem. Not only the fact of independence, but also the appearance of independence. That counts as a substantial threshold for cause. Whether cause for removal exists in a given situation will depend, at least in part, on the seriousness of alleged misconduct and the extent of any nexus that may exist with the governor's professional duties. The key issue is whether the cause assigned truly implies an unfitness for the place or simply represents an effort to secure a more congenial replacement. That sounds a lot like a political consideration. What are we doing here? Without such constraints in place, any perceived or alleged misstep could provide a ready pretext for the governor's removal, a fact that he would surely know and would surely weigh on him as he decided whether and how to vote. Nothing could be more corrosive of the independence that Congress sought to preserve, but it's independence from the president, though, and it's an executive branch agency. I mean, it must be, right? Unless it's a fourth branch. I mean, what else could it be? The court rejects the government's contention that the federal courts cannot grant preliminary injunction ordering reinstatement during the pendency of litigation. Historically, a court of equity could not finally determine whether a plaintiff was validly removed. That was a question only a court of law could solve. In the meantime, however, equity could ensure the actual incumbents of the office may be protected pending a contest as to their title from interference of passion with exercise of their functions. The court decides this application on the narrow ground that the president failed to afford Cook procedural protections to which they were entitled by statute. Okay. And that statute itself is legal? Well, to be honest, we haven't actually decided that it's legal because we're doing equity right now. So technically, we haven't decided the statute is legal. But if it is legal, how does that accord with Article 2, Section 1? Okay, all right. I have questions. I have questions from constitutional principles. Okay, moving on. Under the court's precedents, Cook was entitled to receive notice and some opportunity to respond. When Congress created the Federal Reserve, it gave governors a set of term office permitted only for cause. That form of tenure, a term limit only by a cause, carries with it settled interpretation of common law, one the court has expressly adopted just a decade before. The rule is that notice and hearing are essential before an officer's removal when the term is for a fixed period. Okay. Reagan and Chillhop established the baseline on which Congress legislated and the court must construe accordingly. That is not to say the Federal Reserve governor is entitled to full-blown judicial trial. All that's required is the right to support his allegation by argument, however brief, and need by proof, however informal, before a final decision is made. The protection for removal enjoyed by the governor is consistent with the Constitution. Well, it sounds a lot like we're ruling on the merits right now. The founders knew from experience the calamities that could arise from even suspicion of political manipulation of monetary policy. So when they established the first bank in the United States, they guaranteed its independence from the president's control, and successors did the same for the second bank. That enabled both banks to serve as the greatest regulating wheel of the early financial system. Okay, so the Federal Reserve is just different. Okay, or whatever we call it. It doesn't have to be the Federal Reserve. It could be something else. The federal banking system is different. Okay. I'm having a tough time getting there right now. I have to be honest. Roberts delivered the opinion of this court, and I'm having a difficult time getting there at the moment. I'm still thinking about it, but I'm having a tough time squaring it with the Constitution. Because let me just pull it up just to remind us all, including myself, what exactly it says verbatim. Never hurts to go back to the source material, right? When in doubt, go back to the source. Well, since my margins are playing with me right now, I'll just read it. I'll just read it to you rather than putting it on screen. So I'll just read it. Take my word for it. Article 2, Section 1. The executive power shall be vested in a president of the United States of America. That sounds suspiciously like all of it. Yes, I believe in unitary executive. The Constitution says the Constitution says, quote, the executive power shall be vested in a president of the United States of America. So I've taken the position that if you like an agency law example or analogy, the president is the principal, and literally every single member of the executive, military, civilian, and miscellaneous, is but a fraction of his power. They all get their power from him because he's the executive. He's the guy. He's it. That's what it says. The executive power shall be vested in a president, one guy. He is the executive unto himself. Military general, special ops Scott operator somewhere, guy doing your taxes at the IRS. They're all but fractions of the president. They can only do those things because the president can do those things. They get their power from him. And he's their boss. But apparently except Federal Reserve or other banking system. I'm having a tough time squaring this with the Constitution. I have to say, I'm having a little bit of a problem getting there right now. Maybe it gets better, but I'm having a tough time right now. I'm having a tough time right now. Okay, moving on. The protection to be removed, enjoyed by governors of the Federal Reserve, is consistent with the Constitution. The founders knew from experience that could arise from even suspicion or political manipulation that both banks. The Federal Reserve follows in this tradition with similar degree of independence. What matters is the Federal Reserve remains consistent with the principles that underpin the first and second banks. Namely, monetary policy should not be subject to political interference. In the court's view, Federal Reserve maintains a balance struck by the founding generation under modern circumstances. Yeah, but the founding generation also wrote what's it called? That anti-First Amendment law. It was passed shortly after the First Amendment was enacted, and it's called, my brain is not as sharp as it used to be. This is sad for Uncivil. I can't remember. But circa like 1793, the Congress passed a blatantly unconstitutional First Amendment law. So just because the founding generation did it isn't a thing. It's like called the slander and something law. Sedition? Doesn't sound right. Was it called the sedition? What was that fucking law called? Hold on. Alien and Sedition Act. That's the one. Thank you. Yep, Alien and Sedition Act. That'd be the one. Thank you. Yep, that sounds right. Okay, great. Yep, the Alien and Sedition Act. Sedition, yeah, that doesn't sound right. Alien Sedition Act, yeah. So yeah, the same founding generation that wrote and passed and ratified the First Amendment also wrote the blatantly unconstitutional Alien and Sedition Act. So just because founding generation did it, isn't necessarily the end of the page. Yeah. Alien Sedition Act. That was what we're going for. So just because founding generation, I don't know, man. All right, moving on. The court decides to sow doubt as status one of the nation and the world's most important financial institutions would not quickly unsettle the special arrangement. Okay, because Federal Reserve is now, we're really doing because Federal Reserve. The court rejects the government's half-hearted contention that Cook, in fact, received due process amendment. Cook was entitled to explanation only after Cook had been blah, 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 blah. Roberts delivers the opinion of the court in which Sotomayor, Kagan, Kavanaugh, Jackson join. Thomas files a dissent, Alito files a dissent, Gorsuch files a dissent, and Barrett files a dissent. Who was it who said that Barrett was always on the wrong end of the 5-4, or the wrong end morally of the 5-4? Yeah, not this time. Barrett didn't do this. It was Roberts, and for some reason Kavanaugh. Well, no, Kavanaugh just likes governmental power. So Kavanaugh being on the majority isn't totally a shocker. It takes away presidential power, which is a slight shocker. But yeah, Kavanaugh likes governmental power. So Kavanaugh is kind of your swing justice. Roberts being in the majority isn't a major surprise. The only one that's really a surprise is Kavanaugh, I suppose. And Barrett did not join this disaster of a 5-4. So hey, there you go. Barrett was based. Do I even want to read the majority decision? I feel like I got the gist. And then Thomas, who I have mixed feelings with at best. Yeah, probably wrote some based shit though on this occasion. Thomas, not my favorite by far. I'm not, Thomas and I don't really see eye to eye a lot. But he does write some based decisions from time to time. So Kavanaugh is not surprising. Yeah, I mean, he's a statist. He likes governmental power and he's a statist. And I guess it is the status quo that gives the government power. So yeah, it's not a total shocker. The only aspect of it is that it takes power away from the president. But yeah, it's not totally a shocker. Thomas, President of the United States relief, blah, blah, blah. Yeah, he just does embodying it as a matter of the Constitution. Also, we grant relief even though there's no cause of action. Yep. Congress can't do this. Yep. Okay, fair enough. All right. Yep, that's easy enough. And then we'll turn our attention briefly to the FTC, where we're going to fire. Okay, so he fired some members from the FTC, didn't identify cause. He's told them that continued service is inconsistent with administration goals and pursuant to his authority of Article 2. Filed suit, arguing removal was ultra vires, violated the APA, which isn't really, the president isn't really subject to the APA. So that's a weird argument, but okay. Violated the Constitution. The district granted the motion for summary judgment. Acknowledged that Myers generally permits the power to remove executive officers at will, but explained Humphrey's executor, which is about to die, thank God, creating an exemption for the FTC, and beyond that, to be honest. Court declared the president's removal ultra vires, blah, blah, blah. The for-cause removal procedure is contrary to separation of powers. The Constitution invests the executive power in the President of the United States and instructs to take care of laws be faithfully executed. To vest the executive power in one person was to establish a hierarchy. A chief magistrate with whom the buck stops, and below him various assistants or deputies, like in Basic Agents Theory 101, who derive their office from his appointment, which sounds suspiciously like the core of agency theory. If they derive the power from him, geez, isn't he the principal and they're the agents? Sounds suspiciously like yes. To be accountable to the president, those officers must be removable. The idea that one president would be in charge was by no means a foregone conclusion. That's true. The flurry of state constitutions that followed made a gubernatorial magistrate a new kind of creature, a very pale reflection indeed of the regal ancestor. Almost every state had a nominal governor who could act only with consul's consent, which is true of mayors even today. Some mayors are strong and some mayors are weak. So at the mayoral level, this is true. At the governor level, less so today. Almost every state had a nominal governor who could act only with council's consent. Those early chiefs were little more than chairmen of their executive boards, like mayors in a weak mayor system. The framers chose to depart from that model, for they'd seen its flaws. For fear of monarchical power, the states have proved had devised executives too weak and inefficient to operate with power, proper energy, and vigor. Thus, when delegates at the Constitutional Convention objected to unitary and executive magistrate as the fetus of monarchy, others responded the concern was backward. Instead of being the fetus of monarchy, they explained unity in the executive was the best safeguard against it, for only a single person could produce the vigor and activity necessary to preserve the Constitution. Feels like a backwards argument, but okay. I mean, it won the day, so what do I know? In opting for one president, however, the framers did not opt for the president to work alone. They knew Congress would institute the great departments. How great they are is questionable. Depends what we mean by the word great, I suppose. Depending on which version of the word great we mean. Allow the president to appoint officers therein to assist him in discharging his duties. Duties. These officers were to serve as envoys of the president, not his equals. Like agents. They ought to be considered as assistants or deputies, like agents. Hamilton explained, on this account, ought to derive their offers from his appointment, like agents. Because these officers were subject to the president's superintendence, like a principal would, they had to be removable at will, because that's what principals do. The power to remove was necessarily a corollary of the Constitution. The unity of the executive would be destroyed or vested ostensibly in one man, subject to whole or part to the control and cooperation of others in capacity of counselors. Texts and structures thus both taught the president had to remove those who failed to live up to their duties, lest they fail up to his. Preach. Yeah, the feds are not responsible for debt. Congress is. This is very true. Yeah, Congress is the one responsible for the debt. The feds can spend this much money. Yeah, the debt is 100% on Congress and the presidents who let them get away with it. That is not on the Federal Reserve. Much might be said for the Federal Reserve, but not that. Our national debt is not a them problem. The value of money might be, but the debt itself, not so much. When the first Congress met in 1789, one of the first tasks was to establish the first executive department, with them the department heads. Those officers had to be appointed by advice and consent of the Senate. The question before the Congress was how the officers would be removed. President contended removal was part of the executive power, which the legislature had no right to diminish. It was only with that power he explained the chain of dependence can be preserved. The lowest officer, the middle grade, and the highest made to depend on the president. Madison emerged victorious, and Congress's confirmation of the presidential power gained fame as the decision of 1789. Chief Justice Marshall described the decision as a full expression of the sense of the legislature. What text, history, and tradition settle, the court's precedents confirm. The president may remove his subordinates at will, unless it's the Federal Reserve, in which case, not so much, apparently. As early as, how does this decision square with the last decision? I'm not 100% sure. That's a law review paper, and that's a seminar. How to square those two decisions is definitely something that's going to get much thought. This is going to be the kind of thing that I'm going to be eating some sort of crappy salad in some sort of makeshift ballroom with questionable white tablecloths as I listen to someone drone on and on about the finer points of this thing. That's where this is going. As I secretly consider jamming my own dining knife into myself to end it all. Because of the pain of the CLE. The court's landmark decision in Myers confirmed the president's power to fire subordinates at will. The case arose when President Wilson fired Myers, the postmaster in Oregon, without consulting the Senate, notwithstanding the 1876 statute that required the president to receive advice and consent, not only to appoint, but remove. Chief Justice Taft, let's see. I don't know. Which way is Chief Justice Taft going to go? Hard to tell. Do you think Chief Justice Taft is likely to rule in favor of presidential power or not in presidential power? Which way is Chief Justice Taft going to rule? Is he going to rule that presidents have power, or is he going to rule that presidents don't have power? It's so hard to tell. He could really go either way on that one. Moving on. Chief Justice Taft, who had a minor job in the executive branch before that, noted that in the wake of political differences following the Civil War between Johnson, a Jacksonian Democrat, and congressional Republicans, Congress had sought to curtail the then acknowledged powers of the president on the tenure office. Under that law, the president was required to receive Senate consent before firing most of the officers. This inquiry into invalidity of the act was immediately recognized by the executive and objected to, not just by President Johnson, but by General Grant, who succeeded him. What those events revealed, Chief Justice Taft wrote, was consequently presidential rejection of the validity of the legislature as incompatible with the Legislature Act in 1789. Anyone here a military history buff? Ask a question without you looking it up, because I recently learned this fact. See if anyone see if anyone knows the answer to this question without looking it up. Medal of Honor. The Medal of Honor. What civilian was it awarded to? There's a good trivia question for the day. And what other aspect of this person is notable? Comments in the section below. What civilian was awarded the Medal of Honor, and what other aspect of this person is notable? In fact, unique. Humphreys arose when President Roosevelt filed an FTC commissioner without specifying a cause for removal, contrary to malfeasance in his office. Court ruled against President Roosevelt, distinguishing Myers from explaining that presidential appointment may perform executive functions but exercise no part of the executive power. Because these quasi-functions do not require the use of the executive power, court reasoned Humphreys need only to answer Congress and the courts. Rose gets the point. Rose is correct. That was the other aspect of it that's unique. It was a woman surgeon. So it's the only woman to have ever been awarded the Medal of Honor, and also the only civilian. She was a surgeon on a contracting basis during the Civil War. And she was awarded the Medal of Honor as a civilian and as a woman. Her name was Mary. I think her last name was Walker. There you go. Yeah, Mary Walker. Only woman and only civilian to be awarded the Medal of Honor. Rescinded and then re-awarded, which is also notable, I guess. It was rescinded because she was a civilian, like circa 1930, and then it was re-awarded by Carter. So, there you go. Something to celebrate on July 4th. The women of the Medal of Honor. In Free Enterprise Fund versus Public Company, court reiterated Myers' rule that the president exercises general administrative control of those laws and must be able to remove those for he cannot consider responsible. If anything more is left to Humphrey, the court overrules it. That is no shocker. Humphrey has been deeply questionable for a long time. No surprise there that Humphrey's executor is overruled. Put a bullet in it. It's dying. Humphrey's executor has been a wounded animal for a really long time. And the Supreme Court finally got around to just putting a bullet in its head and giving a mercy kill, which, to be honest, it was long past due. Humphrey's executor is no longer good law, so I guess law students no longer have to learn it, so that's nice. That's a nice relief for the law students out there. I no longer have to worry about that bullshit case. Great. Humphrey has for decades been in search for rationale, and every relevant factor to study decides quality, consistency, workability, consults putting a bullet in Humphrey's head, and it sure does. Slaughter relies on reliance. She argues Congress rely upon Humphrey, but Humphrey's some bullshit. FTC removal powers and presumably every other agency is bullshit. The FTC unquestionably exercises executive power. Because FTC's activities fall within the handheld of executive power, no occasion to define the powers of what exists. Not all offices necessarily come with executive power. Court is left out of the possibility that some functionally traditionally handed outside executive branch may not be encompassed. Like, for example, the Federal Reserve, which you said so literally today, like that, yeah, hold open the possibility. Yeah, one such example would be the Federal Reserve that we just decided just now. That's unfair. Yeah, we've held lots of examples of times the president can't do this. For example, the Federal Reserve, which we decided like literally 5 minutes before this decision came out. So don't you know? Because it's our precedent from like 5 minutes ago. You stupid people. That's lame. I love you guys, by the way. I love you guys, the Uncivilian. I hope you guys love me too. Let's just take a brief break. Just to talk. We're not going anywhere. Let's just talk. I'm in good spirits. As you can see, I recently framed my Supreme Court of Texas and Supreme Court of Virginia thing. That Supreme Court of Virginia thing has been sitting in a tube for 20 years. 20 years. And for no particular reason, one day I woke up and you know what I should do? I should go get it framed. And so I did. I think they make nice additions. So I got my Supreme Court of Virginia on this side and Supreme Court of Texas on this side, which is kind of hard to read, to be honest. I tried putting Texas on the other side, and it just, I don't know. So I got my Supreme Court Texas, United States, and Virginia all in the frame now. So that's pretty cool, I think. So I got that all going for me. So that's pretty cool. I've been off my workout game recently, but I'm getting back into it. So I've been to the gym I've been to the gym 6 days last week. I was off for like 3 weeks, so I was just being like lazy. But I'm getting back into it. So workouts are continuing. My case in the Western District continues to move with all deliberate speed. The government filed a response, as they're wont to do, and their response was mildly hilarious because they talked about issues I can't even be bothered to care about as the attorney. That's like, I can't be bothered to talk about this. All right. I mean, in a legal sense, I'll tell you, it's just like, I can't be bothered to respond to it, right? Because it's just so much bullshit. All right. So my client, what happened for those of you unfamiliar with the case? For those of you unfamiliar with the case, the cops had a warrant for 2 specific items. Only those 2 specific items. They showed up having conscripted the property owner, their word choice, not ours, having conscripted the property owner, showed up to my client's property. The property owner then said everything in sight was his property, right? He's a Snap-on distributor, or at least was at the time. My client was at the time a owner of a route or a worker of a route of Snap-on. He had been working for Snap-on for this guy, a purveyor of Snap-on tools. So is there anything really suspicious about a Snap-on distributor, not the guy who owns the business, but the guy who runs the route? Is there anything odd about a Snap-on distributor owning Snap-on tools? Does that seem odd to anyone? No. Right? Is there anything inherently suspicious about a Snap-on wrench? No. It's a wrench. It looks like every other wrench. Okay. So it's not on the warrant. It's not on the warrant, but that's okay. They've apparently turned this guy into a walking probable cause generator. Like that's a thing. We're going to turn this guy into a walking probable cause generator. And he just gets to point at everything in sight, be like, that's mine, that's mine, that's mine, that's mine. And without any further inquiry of any description, they just start seizing shit. It gets worse. It gets worse. The sheriff then himself goes to buy a device to help loading and unloading. He buys something to help with loading and unloading things. He helps personally, the sheriff helps personally with the loading and unloading of stuff onto the private guy's truck, right? Not a police truck, or no, it's literally a Snap-on truck owned by purported guy. All right. The police then in tow as a caravan with the guy then proceed to his personal barn where he runs his business out of, and unload all the seized property into his barn, not an evidence locker, not a police facility, not even a private rent-a-locker, like there's any shortage of those, right? Could the police have rented a locker from any rent-a-locker? Sure. Did they? No. What'd they do? They used the purported victim's barn and put it in his barn. Did the police secure it in any way? Did they put up locks to prevent anyone from entering the barn except police? No. Did they even put up tape? No. It's just sitting in this guy's barn. At some point, someone calls the guy and says, hey, this is your stuff now. There's no court order. No court has made this decision. It's just your stuff now. Oh, okay. And so he integrates it into his business because he's a Snap-on dealer, uses it, sells or otherwise disposes of it. No court hearing. Okay. We think also, for what it's worth, just as an extra little kick in the teeth, they transported the property across state lines. Apologize, not across state lines. That was a misspeak. Across county lines. The seizure occurred in one county, and they transported the goods across county lines to another county, which might not itself be a problem, except for the fact that Texas law says specifically you can't do that. There's a statute. It says you can't do that. It says shall. It's not discretionary. In order to move property that you seize from one county to a different county, you have to go get a judge's permission. Did they do that? Of course not. So they moved it across county lines without permission, which is a direct violation of Texas state law, in addition to everything else. Plus, so many other problems. Like the police officers were supposed to wear body cameras. Were they? No. There's 5 different police officers. How many of them were wearing a body camera? 1. Did the body camera capture everything? I'm so glad you asked. No, it didn't. It has a 2-hour gap in it, in the middle. Who says that? You? No, they do. They filed it in court. They filed the timestamps. There's a 2-hour gap in the middle of it for some reason. Yeah. The case is totally fucked up. Was there an inventory search list? Absolutely not. Was there an inventory list? Fuck no. There was no inventory list. No, there was no inventory list of any description. The statute, unsurprisingly, requires a written inventory to be provided at the time of seizure. Was that done? Fuck no. Did the police ever do an inventory? No. You know who did do an inventory? The guy. The guy did an inventory at some point. The guy did an inventory. Oh, that sounds suspiciously like something the police are supposed to do. That sounds like it might be police action. Oh, okay. In relation to a warrant. Also, are we trusting this guy? He doesn't know anything about police procedure. He's not a police officer. He's a guy. He's writing down the things he writes about. Does he write about everything? Fuck no. Why would he? He doesn't know any better. He's just a guy. He's just writing down some shit. Did the police do an inventory? Fuck no. There is no inventory. There never was. It's great. The whole case is totally fucked up. Unlawful search and seizure, out the ass. Out the ass. It's unlawful search and seizure, out the ass. It is so broken in so many ways. All right. So there are many, many issues in this case, as one would expect, right? There's a whole bunch of issues. Now, part of the tools in question, the property, part of the tools in question had been gifted to my clients by his father-in-law, who also is a Snap-on distributor. He owns his own Snap-on business, my client's father-in-law. So my client's father-in-law gifted him some stuff because, father-in-law. My client's father-in-law, at some point, relative to the criminal case, produced an affidavit saying, this is the stuff I've given to my son. This is such a bullshit thing. Okay, so in their response to the myriad of issues, they spent like a page arguing about whether or not the notary stamp, which by the way is New Mexico, because that's where he is, right? He lives in New Mexico. The father-in-law lives in New Mexico. They spent like a page arguing about whether the notary stamp was legal under New Mexico law. And I can't be bothered to care. I can't be bothered to care. I mean, if there's not a greater sign of desperation, I don't know what it is, right? Of all the myriad of things they could theoretically try to attack, right? Of all the myriad claims of mine that they could try to rebut or redress or attack or undercut, right? Of all the things they could potentially go after, they spend a page arguing about whether or not the notary stamp of a New Mexico notary is legal under New Mexico law. And I'm sitting here like, I can't be bothered to fucking care. I don't even know the answer. And I can't be bothered to figure it out because it's so ancillary. Like they're quoting a statute from New Mexico that says like the notary stamp has to have these features or these things, blah, 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 right? It's like, okay, fair enough. But what's the case law in New Mexico? I don't know, right? I mean, I know what okay, you quoted me the statute. I'll concede for the purposes of this, assuming arguendo, as the attorneys say, I will assume arguendo that you're correct. What's the case law look like, dude? Now, do New Mexico judges care? Would they care about this in this context? Would a New Mexico judge care? I don't fucking know, and neither do you. I don't know whether a New Mexico judge would give a damn, and to be honest, I can't be bothered to give a fuck. Right? And so, like, the thing is that my clients, the more legally sound problem is that my clients presented this document to the cops at the time of the criminal case, right? I'm coming on after the fact of the civil case. So they presented this document to the cops at the time of the criminal case to show that there was a source of ownership of these items. So unless you're going to sit here and you're going to try to tell me that a Texas sheriff would somehow magically know the finer points of New Mexico notary law, I mean, it looks facially valid. It's, got a notary stamp on it. It looks facially valid. So unless you're going to try to sit here and tell me that a Texas sheriff somehow magically knows the finer points of New Mexico notary stamp procedures, and therefore would be like, oh, this is obviously a bullshit document, I don't have to credit it, then what the fuck are we talking about, right? It's like, what the fuck are we even doing here? I can't be bothered to care. I spent, I think, all of 2 sentences so far rebutting it in my reply that I haven't filed yet. I spent 2 sentences rebutting it because I can't be bothered to fucking care about whether the stamp is legal or not. Who the fuck cares? Is this really what we're arguing about? We have better things to do with our time. What the fuck? Yeah, no, this is pounding the table. I mean, you know right away, like, oh no, Uncivil, oh no, Attorney Kurt Mueller, you're totally full of shit. We have so much body camera footage. You're wrong. We have hours of body camera footage from all the officers. Oh no, Kurt, you're a fucking moron. You can't read the warrant. Didn't you see where it listed all these other items? Oh no, you're wrong. Here's a copy of the handwritten inventory that we provided at the time. God, you're such an idiot. Did they say any of those things? No. What did they spend their time arguing about? About whether the fucking notary stamp was legal. What? I mean, tell me you're desperate without telling me you're desperate, really? I mean, I really want to do this. It's just unprofessional, but I really want to do a like as I'm arguing about it, I really want to do a parens, like, really, seriously, are we really arguing about this? Is this what we've been reduced to? This thing, like, it matters? Seriously? What the fuck? I really want to do that, as a parenthetical, but I don't think the judge would appreciate it, so we won't. That's okay. Fuck me. Also, I'd like to say on a completely unrelated issue that we were very happy, or I was very happy, that I preserved on behalf of my clients the right to review their depositions and correct it, because there were some mistakes that were material. And I know that because I recorded it. I have a recording of it because I noticed it, and I have an audio recording. So I know it was said because I have an audio recording. And yeah, that isn't what was said. So you wrote literally the opposite in your transcript. That's great. Thanks. Great work. Fortunately, we preserved our right to correct it, so the deposition no longer says that. So yay for us. Moving on. Let's go back to this case. Because the FTCs fall within the heartland of the executive, they had no occasion to define where the boundaries of power entails. Not all offices are executive somehow. Federal Reserve, something, something. As the government recognizes the permissibility of tenure protections for non-Article 3 courts is not presented or briefed in this case. Court release those questions for another day. All the court does is recognize what's been clear for a century. Those who fall within the president's general administrative control must be removed from the presence at will. Slaughterhouse counter arguments are rejected, relies on Humphrey and stare decisis, but doesn't get you very far. Slaughter ultimately proposes that the court police Congress's decision necessary only for reasonableness, argues that Congress may reasonably decide the president should be able to remove some duly appointed officers only for certain causes. On her view, Congress could commandeer the Environmental Protection Agency, Department of Commerce, Department of Education, Health and Homeland Security, and some of the Department of Justice. Slaughter were correct. It's not clear why Congress would need to allow the president to say any in firings at all. Slaughter's view is incompatible with our constitutional design, although the Senate's up to decide whether to confirm them. Who the president would prefer to work with, neither the Congress nor courts may saddle him with all that stuff. Roberts delivers an opinion in the court in which Sotomayor, Kagan, and Jackson unsurprisingly dissent in a 6-3. Great. Well, that is the end of SCOTUS Day. And apparently, have we officially decided that we're doing decisions tomorrow? Or are we just assuming that we're doing decisions tomorrow? I'm now reading SCOTUS blog to see, they don't seem to know. They just seem to say it like they know for sure, which they're not, wrong, but ever wrong, but what's on their calendar? 30th, opinions. Opinions are expected. Okay, tomorrow is the day. Tomorrow's the day. Tomorrow we're going to get it all for whatever value it has. Tomorrow is the big day. We get transgender in sports, 2 cases, which are going to say that states can regulate that and can kick out the transgenders. I'm pretty confident about that. So we got that going for us. In what's probably a 6-3, with the left-leaning saying how mean the court is to the transgender people. Then we have, so there's 2 of those tomorrow, which will probably come down the same way. There's something about campaign finance, which I honestly don't even remember what the issue is. And then birthright citizenship, which will almost certainly be decided against us. What is this campaign finance issue? Is it important? Why is it reserved? Like, what exactly is the issue? Okay. What is this case? Cumulative IQ scores? What the fuck is this? Okay, here. Whether the limits on coordinated party expenditures violate the First Amendment, either on face or as applied to party spending in connection with party coordinated communications. What a fucking like niche little decision. This is some boring banal shit. Kind of important. I'm working on how important it is. I'm reading a fast summary of the case, and I'm not sure how much I can be bothered to care. So it's, can political parties be restricted in the amount of money they spend in coordination with candidates for office? Okay. I mean, that feels like a very dry decision to me, to be honest. That feels like a very, compared to the transgender and the birthright citizenship, that feels like a very, very dry decision. I mean, we'll cover it for whatever value it has, but yeah, I don't know, man. Him versus Smith, and the future is a capital punishment. Oh yeah, it was decided per Kerm. Oh, it was digged. It was digged. It was dismissed as improvidently granted. Okay. Yeah. All right. So the Supreme Court never heard it. We have no idea what you're talking about. Okay. So the cumulative IQ thing was digged. Okay, that makes sense. All right. What else should we talk about today? I guess I'll make a video on. I probably should make a video on this Trump thing. Trump versus Cook and Trump versus Slaughter. I'll see if I can squeeze out a video today about that and do it as a late release today. All right, but we'll be back on tomorrow. Should we design? Let's design a thumbnail for tomorrow before we leave. That'll be fun. What should we do as a theme for tomorrow's thumbnail? We already did circus for today. What should we do for tomorrow? Something like Final Countdown, something like post apocalyptic. All right, let's see what my thumbnail generator can do for today. A green card with my face on it. It's not the worst idea I've ever had. Is there really a new USA passport with Trump's image on it? Nothing would surprise me at this point. You know, it occurred to me for the reflecting pool with algae, like, wouldn't it be easier to just put some like copper rods in the water so that the copper would kill the algae? Or am I overthinking this? That way you wouldn't have to use pool chemicals and stuff. It's a big pool, so using like pool cleaner and pool treatment methods seem inefficient. Some copper rods seems more practical. Someone would steal the copper? Probably. How was it done before? It's never really been done well. So, okay. Okay, my thumbnail generator's got some pretty spicy thumbnails. All right, I'm liking the way this looks. This is nice and spicy. There's a limited edition passport. That's a combination of words I've never heard before. A limited edition passport. That's definitely different. My thumbnail generator is now generating a variety of styles. We've got some choices. You could probably do it so like you have the copper like integrated into the lining. There's got to be like a way to do like a copper infused paint or something that you could paint with, so that it would be a little bit harder to steal, since it'd be like you could paint it right into the lining or something, or infuse it into the lining. There's got to be a way to do that. Just an idea. Trying to help. Judgment Day is a nice little theme. All right, we got three choices. You want to see our options for the thumbnail? You guys can help me decide. For tomorrow. All right. All right. So here's option one. This is pretty good. Judgment Day, LGBT plus sports, birthright citizenship, June 30th, 10 a.m. Little live indicator, me looking horrified, gavel cracking, Supreme Court cracking, fiery in the background. That's pretty good, man. It's a pretty good thumbnail. I like that. That's option one. Option 2, final day, live June 30th, 10 a.m., LGBT sports, Birthright Citizenship against Supreme Court collapsing. Ray of light, a little dour. Yeah. We got option 3. Hold on. We also got this one, which is a little campy. This is like some sort of Back to the Future kind of hybrid bullshit. Final rulings, LGBT sports, Birthright Citizenship live, clock, Supreme Court. I think I like option 1. I think I like option 1 the best. Yeah, I think I like this one. Yeah, I think option 1's the winner. I like option 1. All right, let's create it for tomorrow. I'll redirect you there while I'm talking. That way you can like it and stuff. Let's create a new stream. Create new. Thumbnail. Okay, that's a good looking thumbnail. Now we just need a title for it. It's going to be really catching. Okay. Supreme Court Judgment Day. LGBT and Birthright Citizenship. That's a good one. Yes. Supreme Court Judgment Day, LGBT plus sports and birthright. Final day, Judgment Day, Scottish Judgment Day, Birthright Citizenship, and LGBT plus sports. Just Scottish Judgment Day. (6-3) on trans. 5-4 on birthright. No. 7-2 is better. You'll get Thomas and probably Alito. I don't think you're going to get 5-4 out of birthright, in my humble opinion. But I was wrong twice today, so what do I know? All right, so this is going to be tomorrow, and it's going to be 8:45 my time because I'm an hour behind the Supreme Court. So that's 8:45 my time. Great. Now I'm going to go ahead and redirect you to there so you can go ahead and like it and get engaged and do all that wonderful YouTube stuff. Make sure to hit the like on the new one on your way in. All right. And with that, I'm going to go and hit end stream. It's been a lot of fun, guys. I will pick you up tomorrow. Until next time, I hope all's well. Cheers for now, my friends, and goodbye.